Good morning, guys. What's up? Hey, Nancy. Hey, Judy. Hey, Nichelle. Hey, Carla. What happened to Wiggles and Marty? They got lost. Hey, Jennifer. Oh, we're going to talk about the read technique, Judy. The read technique is an interrogation method used by law enforcement throughout the United States and has led to countless confessions. Researchers found that not all of those confessions were legitimate. The technique primarily relies on deception, coercion, and aggressive confrontation to secure confessions. There's Wiggles. There's Marty. Oh. That's what happens when you have to work. You miss stuff. I miss stuff all the time, and I'm right here in charge of everything. That's scary. So it said that it started at 11. First it said 10:30, then it said 11. So it's 11 and nothing is happening. And I think they said 10:30 because she told the lawyers to be there at 9:30, which is 10:30 my time. And she said they would start at 10, which is 11 my time, and it's 11 and nothing. This judge is like not strict about time. She's sassy. I like the sass. I don't like the not strict about time. Because lunch is like, y'all let us know when you're done eating. No, 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 no. No, no, no. This must be like the first, or maybe one of the first trials she's ever had that is streamed, because you can't do that. You gotta let us know. But I feel like Saturday was a punishment for the lawyers, because on Friday, when she told them we were having court on Saturday, she said, and if you want Sunday off too, you gotta earn it. So I feel like Saturday was punishment for something. And then yesterday, when they came back from lunch, she was mad. It was something about a witness that the defense needed to take out of order, but the prosecution was objecting to taking that witness out of order, and there was no other way but to take the witness out of order because of travel arrangements. And she said something about the prosecution was either gonna have to overrule the prosecution's objection or put that witness in jail, because the witness could not physically get there in the spot that they needed the witness to get there. And she was mad. I mean, it was like a logistics thing. They could not get the witness there. It was a travel arrangement problem. And I guess she was mad at the prosecution for not being more flexible. I don't know why. I really don't know why she was that mad about that. But she was mad. And so we were here until my time, like almost 7:30 last night. I was so tired. By 7:30, I'm kicked back in the bed watching a Disney stream, crocheting or diamond painting or whatever. I was sitting here trying not to doze off. I was so tired. I'm getting old, y'all. I go to bed early. Not at 7, but like I'm all chilled back in my jammies. I was so tired. So the rule, like, like if I was a lawyer in this county in Tennessee, I would be terrified if I got. I would be terrified if I got called up in front of this judge. I would be like, oh my God, no. No. Because you do something to tick her off, man. You're going to have to stay late, come in on the weekend, man. And now we're starting late today. Why don't they start at 9? Like, most courts start at 9. Well, no. Was today the day she had something extra on the docket to do before court? Or was that yesterday? I thought it was yesterday. I don't know. Thank God my husband likes frozen dinners. Because if I had to do this and cook, oh, good Lord. He would be getting like the easiest things to cook ever. Stuff that I could just slap together and throw in the oven. Which that's usually what he gets when I cook anyways, because I hate to cook. This heating pad is not in the right spot and I'm burning my butt, not my back. He loves pancakes, but waffles are easier. So a lot of times he gets waffles instead of pancakes. We do breakfast for dinner sometimes because it's easier than doing breakfast for breakfast because I'm not awake yet. I don't like to get up and cook a great big breakfast in the morning. So we have breakfast for dinner. And then as you guys probably have noticed, I've started just doing different variations of toast. This morning it was peanut butter toast. I think it was yesterday. I had cinnamon toast. And then some mornings it's peanut butter and banana toast. Whatever's quick and easy. All right, come on, people. Today's the last day of September. Day 7. The other trial that was going on the same time this one was, where I guess the father killed his daughter's boyfriend. It ended in a hung jury. So whenever that one comes back around, we might do that one. Oh, that sounds good, Nancy. I've never tried that. That sounds really good. Ooh. Really good. I might try that. Okay, so we are on the defense's case now. And I have to say, I don't know why my nose is itching so bad today. I have to say that I was impressed with Waggle Hands. I don't know her real name. And I know that Judy doesn't like her because of I'm not crazy about her presentation either. And I do think that this guy's guilty Of course, we haven't heard all the evidence yet. We're not supposed to decide yet if we're on the jury. But I was impressed with her cross-examination of, what was his name? I don't know why you guys watch me, because I don't remember anything. That's why I do notes. Shoot. What was his name? Oh, I should have remembered that. Jacoba Boyd. Sergeant Boyd. Because Detective Yummy Pants. Yeah. Detective Yummy Pants. Because she was picking out, and yeah. Yup. Me too. Oh, that sounds so good, Nancy. I am definitely going to try that. Oh, that sounds so good. Like, I don't think he did anything wrong, but she was still picking things out of his interrogation and saying, you know, this was coercive and this is coercive, and I thought she did a really good job with her cross-examination of that. Even though I don't think he was coerced. I mean, I don't think that was coercion. I just think that was a detective trying to get him to tell him the truth. But I was still really impressed. I thought she did a really good job. I don't think it's going to convince the jury that it was a false confession, but I think she did a good job. And I hope you guys understand that. You know, like Peter Tragos does that, and people are like, well, you're biased, and you shouldn't be saying, like, who was it that they got mad at him? Oh, every time he would make a point about Brennan doing something good in the Karen Reed trial. You know, when he would make a good point or have a good or a good a good direct or a good cross, they would say something like bad about Peter. Not like a good argument against Peter, but like something bad about Peter. Like, you're biased or you're whatever, you know, like insulting him or something like that. And no, that was just Peter being Peter, like critiquing the lawyer himself, not the case, not is she guilty or not guilty, just critiquing the lawyer's performance. And so that's what I'm doing with her. I still think this guy did it. I still think he's guilty. And I still think the jury's going to find him guilty. And I'm not a lawyer. I know nothing. I shouldn't say nothing. By now I know a little bit about the law. But I think she did a good job. And I'm so glad. Because I don't remember hearing him say that in the video. Of course, the sound was crap. But I'm glad that she highlighted that part of the interview. Because that was the highlight of yesterday. Was the you'll be dodging dicks for 50 years. Because I don't remember hearing that. And I thought it was pretty funny. And then she asked him, that didn't mean that he was going to go to prison and get raped in prison. And he was like, no. With a straight face. Under oath. And I was like, that was impressive. That was really impressive. I really believed that he was telling the truth. Even though I knew he wasn't. So that was kind of the highlight of the day for me yesterday. And then that expert yesterday, I didn't dislike him. I didn't like him. I was kind of apathetic about him. I didn't really care one way or the other. I get what they were trying to say. I do think 10 hours is an awfully long time to be interrogated because, okay, so you have the right to an attorney. You've been arrested for whatever, and you say, I don't want to talk to you, I want an...
What do we need to take out?
So you ask for an attorney, yet you're still... They're like, well, you can't go home. You're being detained. And then you're still there for however much longer until you get to see a judge. So if you're young and naive and you want to go home, I can see you not wanting to say, I want an attorney, thinking that if you tell them what they want to hear, they will let you go home. If you're young and naive, I can see that happening. So I can understand how a false confession can happen. Because a lot of times when you do ask for an attorney, you're stuck. You know, you're going to at least stay overnight until you're appointed an attorney. If you could get an attorney, or if you could say, no, I'm leaving, and I'm going to go hire an attorney, and then I'll be back. But you can't always do that. So it is a sticky situation to be in. I just hope I'm never in that situation, like falsely accused of something, and then say, no, I'm not going to talk to you, I need an attorney, and then you're like stuck in jail overnight. No, that's never going to happen to me because I don't go anywhere. Where do I go? I go out to eat a few times a month, maybe, with my husband. And I go to Disney. Well, no, I haven't been to Disney but once in a long time. But I'm going to start going to Disney. We're going again next month. I used to go to Universal. So I go to theme parks and restaurants. And that's about it. I don't go anywhere to get in trouble. Well, people get in trouble at theme parks. But that's usually because they've been drinking. I don't drink, so I'm pretty safe, I think.
Mr. Christensen is now in the courtroom. Mr. Isabelle, if you please come around
That's
to
what
the
I'm
seal.
saying.
Follow the directions of the
I
deputy.
That's what I'm saying. I don't think I'm even going to get falsely accused of doing anything. Like, I'm not going to ever be in the wrong place at the wrong time because I don't go anywhere. If I'm just sitting here at home most of the time.
Step this way, sir.
But see, this is the way my brain works. If I get a weird pain in my head, I start packing a bag for the hospital in my head. I'm like, oh no, I got a pain. Just in case I have to go to the hospital, what do I need to pack?
Stand on the top of the seal, face the judge, raise your right hand.
Do you swear or affirm to tell the truth?
Okay,
Please
you're
have
right.
a seat. Watch your step, and I'll need you to
You're
speak
right.
up for the benefit of Madam Court Recorder,
You're right.
who's recording these proceedings, sir.
Good morning, Mr. Isabelle.
No way.
You have sat through this trial, right? And delivered all the proof along with us.
You got to speak up, Mr. Massey. Thank you. Try to get you an additional microphone.
Delivered all the proof along with us.
Yes, sir.
And even before that, we've gone over the proof that we expected to be shown in this case, even showing PowerPoints and those kind of things, so that we made make sure you were aware of all the discovery available. And after hearing the proof today, of this past week and yesterday, and knowing that you have a right to testify, that's an absolute constitutional right to testify and tell the jury whatever your side of the case may be. And
Yep.
no one can make that decision, as Her Honor told you yesterday, nobody but you. And what you do is you can look to others for advice, like you look to us for advice, you're lawyers. And you talk with your family as well. Right? And you put, have you made a decision as to whether or not you wish to testify? Have you made a decision?
Yes, sir.
What is that decision, please?
I wish to testify.
You do not wish to testify.
No, sir.
I have no other questions. Thank you.
Do you mind if I just, for the record, flesh out some other things?
Wait a minute.
You made a decision to not testify, and I'm certain that Mr. Massey and Ms. Fuchs have informed you that the jury will be
What?
informed.
He's
that they can't
not
hold that against
testifying.
you.
Why are you on
You
that
have the
witness
right to remain
stand then?
silent. Has anyone made any threats or promises to get you to not testify?
No, ma'am.
You're entering into this season, this session of not testifying. It's your choice and yours alone. And that you understand that no one can draw any inferences, meaning no one can assume what you would or would not have said just because you didn't testify. And that's basically what I'll tell the jury. They can't hold that against you. You understand?
That's weird.
And you've had enough time, not only just this morning, because I know you spent some time with your lawyers this morning to discuss this issue. And you did yesterday, right? I need more.
Yes, ma'am.
And you don't need additional time to discuss this decision.
No, ma'am.
You're clear, and you're clear on what you're gonna do.
Yes, ma'am.
And you're satisfied with what they've been able to share with you as far as where we've been going throughout this process. They've been accessible to you. You've been to court many times, correct?
Yes, ma'am.
And they've shared everything that they have with you.
Yes, ma'am.
Do you need any additional time with them this morning before we proceed?
No, ma'am.
Do you make that?
Why is the witness? I'm not all excited for nothing.
Next up.
So is the jury there? They usually do that outside the front door.
You are going to move for rest when the jury comes back.
The jury.
They're resting. So the jury's not there. Okay, well, if we're going to be done with this trial today, there is another trial. So whenever they get done with this trial, What? Why did we stay so late last night? Woman, good Lord, Judge. So what was the witness that they needed to take out of order? I am so confused. Anyway, they're done with this today. There's another trial starting today that we just have to play a little catch up. I don't know what is happening. This has been the weirdest trial. I've never done a trial on a Saturday before. I don't understand why we did that. Evidence with that expert witness that it could have been a false confession, but he was not testifying that it was. Only that it could have been.
Judge, the jury's in the courtroom.
Are they doing closing arguments and charging conference and all that today? Are we done now?
Good morning.
Good morning.
Ladies and gentlemen, it is Tuesday, September 30th, and what a week it has been, right? Let's get started. Mr. Massey, Ms. Hughes.
John McClain, on behalf of the defense, the defense rests.
Does the state of Tennessee wish to present any rebuttal?
No, Your Honor.
Ladies and gentlemen, you have now heard a break while I go over your instructions with the attorneys. I'm going to give them a few minutes to prepare their closing argument, if any. The state may give a closing argument and the defense may give a closing argument. If the defense gives a closing argument, the state will be allowed to give a final rebuttal argument if it wishes. This is because the state has the burden of proof in this case. During this break, even though you have heard all of the proof, do not discuss the case amongst yourselves. It is now 10:26. I hope to be with you very soon, and I hope that we can work, the lawyers and I can work rather expeditiously so as to get you back in and go over these instructions. I'll see you in a minute.
Ladies and gentlemen, jurors, leave your pen and pad in your chair. Follow me.
Notice I didn't mention lunch yet. But I will. You may have a seat. Ms. Harris sent out preliminaries that everyone had. She sends them out to everyone, you guys discuss. It's just been passed a request for lesser included offenses. Has the state had an opportunity to review what Mr. Massey has filed?
We are just receiving a copy, Judge.
It appears as count 1 and count 2, this litigation team for Mr. Isabelle is asking for second-degree murder, reckless homicide, and negligent homicide. As to count 3, first-degree felony murder, they are asking for second-degree murder, reckless homicide. As to count 4 of the indictment, aggravated child neglect, they're asking for child neglect. As to count 5, especially aggravated kidnapping, aggravating kidnapping, and kidnapping as lesser. I have thoughts, but I'd like to hear from the state.
Judge, we just reviewed the proposed lesser included, and we're in agreement with those to be charged to the jury.
Under State v. Burns, the court must determine whether any evidence exists that reasonable minds could accept as to the lesser included offense. Negligent homicide is not on the table for the court under count 1 and 2. Neither is reckless homicide under counts 1, 2, and 3. The court must view the evidence liberally in the light most favorable to the existence of the lesser included offenses without making any judgments on the credibility of such evidence. And then I must determine if the proof provided was legally sufficient to support a conviction for the lesser included offenses. This is a practical two-step analysis under State v. Burns. I'm happy to share it with you while I take a brief recess.
What's in the brief recess?
Oh, let's see. Okay, so we've got deputy shoots girlfriend. I don't know if she lived or not. Hang on. Deputy shoots girlfriend trial. That is Florida v. Leslie. I don't know how to say his last name. Boileau? Florida Deputy Leslie Dale Boileau described the alcohol-fueled gun training set. Oh, that's not good. That is not good. Described the alcohol-fueled gun training session that ended with his girlfriend shot dead between the eyes as sloppy. You think? Oh, jeez. Investigators say alcohol, loaded weapons, and carelessness led to the fatal mistake. Boileau is charged with manslaughter in the death of 25-year-old Paulina Wright. Oh, good gravy, Marie. So that is starting today. There's a bond hearing right now. Oh, it's not. It's doing it's on court TV, but you know that thing where it's not. I mean, we've done some hearings like this where they have like stuff on the side of the screen, and then their talking heads pop in and out where they pause it and stuff. And you know, I don't know if you guys heard about it. There's an Amish mom that threw her son in the river and said, yeah, yeah, she absolutely did. Don't mess with guns while you're drinking. That's stupid. And so in the plotting parents murder trial, that was a hung jury. They deliberated for 4.5 hours. Well, did they make him go back and try more? After just 4.5 hours, they were deadlocked 6-6. So he's going to remain in custody, and then there's a new trial expected to be set for next year. So depending on what our schedule looks like, that's a possibility for next year. I would show y'all, but I don't know how long it's gonna be before they come back. Did anybody watch Tyler Robinson's hearing yesterday? The judge made a speech, and I've never heard a speech like that made by a judge.
Please be seated. That would likely. And how much? Only speak when I'm needed or it is necessary. But today I do wish to provide guidance and expectations that you can have for this court and wish to end. Your Honor, thank you.
No, Your Honor, thank you.
Okay.
As we are at the beginning of this case, it is my intent to only speak when I'm needed or
Can you guys hear that?
it is necessary. But today I do wish to provide guidance and expectations that you can have for this court and wish to enter an order as well. As this case moves forward, Mr. Robinson's constitutional rights will be protected at every stage. He sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. At the same time, and as applicable, victims are entitled under our Constitution to be treated with fairness, respect, and dignity, free from harassment or abuse. Justice demands that both of these principles, the rights of the accused and the rights of victims, be honored without compromise. I remain steadfast in my oath that I made 56 days ago to support and defend the constitutions of the United States and of Utah. I will carry out my duties with fidelity, transparency, and impartiality, treating every person who appears before me with the dignity and respect they are inherently due because they are human beings. Let me be clear. I will not put my finger on the scale of justice. These proceedings will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys and participate in these legal proceedings. Counsel, regardless of who is watching, whether it is the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. I encourage each of you to give your very best to this case. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice. In regards to the next hearing, counsel, on that October 30th date.
That is the judge in the Tyler Robinson case. Utah v. Tyler Robinson. That's the guy that killed Charlie Kirk. I've never heard a judge make a speech like that before. I don't know what he thinks is going to happen. But I've never heard a judge make a speech like that before. And that is just his second hearing. And they also said that there was extra security outside the courthouse yesterday. And Tyler Robinson he wasn't even there in person. So, did they think someone was going to shoot the attorneys? Like, I don't know. And the hearing itself only lasted about 10 minutes. I know. But these are only, okay, the first hearing, I don't know what all these things are called. I don't know what the first one was called. The first one was like, someone from, I guess, the public defender's office was there. But he wasn't there to represent Robinson. He was there to say that he needed an attorney appointed to him. And I guess because it's a death penalty case, because to be a death penalty lawyer, I think you have to have like some kind of special training or something, or special experience. I'm not sure. But, so the lawyer that was there was from the public defender's office, but he wasn't a death penalty lawyer. So he was just there to say, I can't represent him, but I'm from the public defender's office. So this one was a waiver hearing to see whether or not Robinson was going to waive his right to a preliminary hearing, which he is not. So there's going to be a preliminary hearing. So these are hearings about whether or not they're going to have hearings. Which seems like a big waste of time to me, but whatever. So it was a hearing. Find out what's happening, and we're going to have a hearing on... Oh, did I not write it down? I did. October 30th. And I'm watching these myself because I didn't know if you guys were interested or not. And I do want to watch... I mean, the trial is probably not going to be... I don't know when. I mean, it could be years from now. Who knows? Yeah, it could. The actual trial could be years from now. And I don't know if I'm gonna stream it. If I do stream it, I will probably either make it subscribers only or members only, because I don't want a bunch of creeps coming into my chat causing trouble. And if I decide not to stream it, y'all are gonna just have to deal without me till it's done, because I'm watching it. So but they were talking about the state was talking about the thousands of witnesses that saw it happen, as if they were going to try to subpoena everybody that was there, which I don't think that's going to happen. But I'm thinking that little speech was his politically correct version of, homie, don't play that. We're not having any shenanigans in my court. His rights are not going to be violated. I don't care who he is or who he shot. I wonder if they're gonna. I wonder if they're gonna give this Amish mom bail. Have you guys been following this, what's his name? This singer. David? Is it David? How do you pronounce his name? It's D4VD. I know EDB's covering it, but I don't know who this person is. I haven't been watching it. All I know is that he's a pop singer. I never heard of him before. And they found, let me see, where'd it go? Well, I lost it. Well, I just saw it. I don't, shoot. I can't remember if it was a body. Yeah. Oh, it's a rapper? I thought it was a pop singer. Rapper makes more sense. I don't know if it was body parts or a whole body they found in the trunk of his car. I can't find it. I just saw it. Now it's disappeared. She was 15? Oh, man. Okay, this one says okay, the deputy shoots girlfriend trial. Law and Crime's calling it gun gun cleaning gone deadly trial. A Florida deputy, Leslie Ballou, like Baloo the bear from Jungle Book. How do you say his name? I'm gonna call him Baloo because it reminds me of Jungle Book. A Florida deputy has been charged with manslaughter after accidentally shooting his girlfriend while cleaning his gun. Police say his girlfriend, Paulina Wright, was found with a fatal gunshot wound. Investigators claim weapons were also discovered at the scene. During questioning, Ballou claimed the two had been handling and dry firing the bird, allegedly causing Wright to suffer a gunshot wound to the head. He now faces a manslaughter charge and could get up to 15 years behind. Happened. Now I really want to watch this because I want to know what really happened. And now I'm kind of interested in the rapper case. I usually don't watch rapper, like the YSL case, like the gang kind of case things. Like, I don't care. Diddy, I didn't care. I didn't want to see anything about that. Of course, that wasn't streamed, but I was like, I don't care. I don't know nothing about Diddy. I heard about the baby oil, and I was like, that's all I need to know. I don't need to know any more than that. I don't need to know anything about no baby oil. Can we see which one, Nancy? The deputy one, that one starts today. Yeah, I think if this goes to the jury today, I think we're going to jump over there and try to get caught up with this one. Because it just started today. So if they get done with closing arguments, I think while we're doing jury watch, we will jump over to the other one. And I think instead of doing the new stream thing, I will just go over there and then I'll sort it out later. Or maybe I'll fix the thumbnail to include everything or something. I don't know. I'll fix it. I'll figure it out. I don't know. I'm tired of waiting. Are maybe they're doing Are they doing the charging conference now without letting us listen? Maybe, because I can't figure out any other reason for why we would be having this long of a break. Seeing as how we just got there. Okay, I gotta turn the sound off, but I gotta show you these floats. Because I want them. Oh, wait, I gotta back up. No, go back to the beginning. I think I want one of the covered ones. Not like the ones at the end that's like the big, like I like that one. Really like that one. But like that one where it's just the big giant inflatable head, that serves no purpose. It's cute, but see, now that serves a purpose. Cuz if it's like really hot, you've got a shade over you. That's pretty cool too. That's my favorite. I bet they're like super expensive though. I love when Megatron insults people. Now, when we used to go to Universal, we all had annual passes. Me and Travis and my two stepdaughters. They only like rides. I do everything. When I go to a theme park, I'm an everything person. So I only got to see Megatron from a distance. It was like, we're not standing in line. We're not standing in line to meet a character. Oh, no, honey. Megatron is an experience. You're not just meeting a character. You're getting insulted. You're having a conversation. I want, it itched when the port was there, and it still itches with the port out. I don't want to itch anymore. I wonder if it's ever gonna stop itching. But now, what's the other one's name? Bumblebee. Bumblebee comes out too. But Bumblebee is like Bumblebee in the movie. He only plays music. Like he doesn't talk. He doesn't talk. He just plays music in response. Megatron is the one that's funny. He's hilarious. Scar. It's a scar. Scar's itch. And I can feel it. I have a little stitch right there that is supposed to be dissolved, and it's not. That's what itches. The other day, that was where my shoulder was replaced. The other day I was like, because I've got, how many ports have I had? 3? Yeah, I think. So I've got like 3 scars from ports, and then the one from my shoulder, and then one under my arm from when I had lymphoma. So the other day I walked up to Travis, I'm like, well, there goes strapless dresses. And he's like, what are you talking about? I was like, look at all these scars everywhere. It's like a road map. And I'm like, so what? I'm like, I'm just teasing. I'm not going to wear strapless dresses. You mean scratch? It itches, so I scratch it. What are you, 3? That's one of the old wives' tales that is true. When it itches, it means it's healing. You have chest tube stars? Stars. Scars. Oh Lord, I don't ever want to have chest tubes. Just the thought of chest tubes. I've never had them. I've just taken care of them. Like, they're scary to have to take care of. Oh, yikes. I'm so sorry. Good Lord, woman, they're doing the charging conference without us. It's boring, but it's not as boring as just sitting here listening to me ramble. Oh, no, I need to unpin this. No, they sat him in the witness seat like he was going to, only to ask him if he was going to, and then he said no. Down the middle of your back? I love you too, Nancy. I love all you guys. I have scars all over, but I call them my battle scars. Yeah, they set him in instead of most of the time when the judge asks if you're going to testify, and the judge asks, not the lawyer. They sat him on the witness stand and the lawyer asked him. So I thought he was fixing to testify. I got all excited. And then he just asked him if he was going to testify, and he said no. I was like, okay. That's different. I guess. I don't know. If I knew how long this was going to take, we could jump over to that other trial right now. But I don't know how long they're going to be. I really wish they were showing this. These judges need to learn how to live stream trials. To think of something non-confrontational or controversial, rather. Confrontational. To talk about. Everything that I see that's popped up on my YouTube is something that could get me in trouble. I start talking about it. Oh, I know something we can talk about. Dever. Why will you have a headache from peeling potatoes? Judy. Um, why? I thought you were going to say you were allergic or something. I used to get headaches when I ate onions. And so I had cut out all onions. And then a friend of mine told me, actually, it wasn't a friend of mine, it was my dad's girlfriend, who we were friends. I thought we were friends. She was using me to get to my dad. Anyway, she said, yeah, that happened to me too. But then I found out that I could eat them cooked. That whatever caused the headache, her doctor told her this. And I forgot. Oh. Whatever. I don't remember if she even told me what it was. But whatever it is in headaches that people are allergic to, that whatever it is in headaches. Good Lord, Debbie, let me start over. Whatever it is in onions that people are allergic to that gives them headaches, when you cook an onion, it cooks that away so that it won't give you onions. So it won't give you onions. Good Lord. Jeez, I give up. This is fibrofog, you guys. This is fibrofog. This is what happens when you have fibrofog. Okay, I'm going to start over again. When you have the allergy to onions where you get a headache, it only happens when they're raw, because when you cook them, whatever the thing is in the onion that causes the headache cooks out. And I didn't know that. I cut out all onions, and I love onion rings, and I love the whole fried, like the bloomin' onion or the cactus blossom at Texas Roadhouse. And she goes, oh no, you can eat them cooked. So then I started eating them cooked again. And then I got the Doth piercing, like I've told you guys about. And now I can eat raw onions again, and it doesn't give me a headache, which I find strange. How does this cure an allergy? But it did. This is true. Absolutely. That is what fibrofog does. It. You literally, you say the wrong word. You know the word you want to say, and there's a scientific word for that too. I don't remember what it's called, but I know the word I want to say, but a different word comes out of my mouth. It's part of fibrofog, and there is a name for it. I just don't remember it. But that is true. I do know what I'm talking about. It just doesn't come out right. No! I'm sick of it. So, Marty, are you allergic, like, you'll break out in hives and itch kind of allergic? Or do you have, like, runny nose, eyes kind of allergy? Yeah, because onions and garlic are in the same family. That is why I don't do yard work. I mean, I have a bad back already, so if I were to go out and do stuff, well, that and because I'm allergic to nature. If I sit down on the grass, I mean, if I'm protected, like if I've got like long pants on, long shirt, everything, I'm pretty much okay. But like if I'm in shorts and like a tank top or something, like a lot of skin showing, and I sit on the grass, I'll break out in hives and start itching because I'm allergic to grass. That's sad. I would be sad because I love onions and garlic. I would be sad. Of course, if you're allergic to something, you probably haven't had it very much, so you don't really miss it, I'm assuming. Oh, I knew you told me you were allergic to a fruit that I love. I was thinking it was strawberries. No, it's watermelon. I love watermelon. I'm so glad I'm not allergic to any fruit because I love fruit so much. If you, well, I don't know about foods, but I'm allergic to animals. And the more I've like conditioned my body, I guess, I'm not as bad allergic to them as I was when I didn't have them. Now that I have them, I'm not as allergic to them as I used to be. When I first had them, I stayed allergic. Like, I mean, itching all the time, watery eyes, nose, sneezing, everything. But I don't do that. Not bad. Like, every once in a while. If I'm like really cuddling the dogs, they'll make me itch. But if they're just like next to me or I pet them, I'm fine. But allergies are weird. Okay, so what was I gonna remember what it was?
Run back and forth.
We are still working our way through the instructions. I think that there was one page that we all agree there was a little phrase that needed to be taken out.
And I just gave her that, if there was abuse and there was neglect, and that.
Okay, so if it is now 11:12, what time would you like me to revisit you? I understand this. How many pages do you have there?
24?
I understand you need to go through them, and I understand you want to go through them with Mr. Massey and with Mr. Isabelle. I'm not trying to rush you. I just need to know what I'm doing.
Is it?
That's
Gross.
I would say, yeah, there. 20 minutes?
That's perfectly fine. I don't want you to feel as though I'm ignoring you and I'm not here. I'm here. You just let me know when you're ready.
And
What we do, Judge, we have, and I think Mr. Steele and Ms. Carpenter can speak better on this, but we do agree, all of us, I think, agree that reckless homicide and negligent homicide should be included as lesser included under the first-degree murder counts, and they've been looking at the case law, but I think we all agree that should be in there.
Your Honor,
Okay, so articulate for me what evidence supports reckless and negligent under first-degree murder count 1 and 2?
I would, Your Honor, the state and the defense would be asking for the inclusion of reckless homicide and negligent homicide, specifically looking at State versus Brown, which is the Supreme Court Tennessee decision from 2010.
Is that Benjamin Brown?
Yes, Your Honor.
Yes, I have it.
That case it's somewhat factually similar, but it's a child abuse case. In that case, the child was shaken, reportedly, or that's what the jury found, and those were the injuries that led to the death. The charges include premeditated murder, I believe, murder in the perpetration of aggravated child abuse and aggravated child abuse. So the difference is abuse versus neglect, but generally factually somewhat similar. There, the Tennessee Supreme Court did go through, and it looked at Burns. It looked at State versus, is it Eli as well? and looked at the instructions that were given specifically by the court in that case were first-degree murder, stop. It wasn't second-degree murder, it wasn't criminally reckless or criminally negligent. The Supreme Court of Tennessee then looked at the mens rea requirement of knowingly under the facts that were in that case. And the Tennessee Supreme Court found that knowingly was fairly raised. And then went further and said, so second-degree murder should have been instructed. And then the court specifically then goes to on page, I believe it is 433. I'm sorry, I have it highlighted, but I lost it. Oh, it's on 433, carrying over into 444. To quote the court, it says, it necessarily follows then that the trial court also erred in failing to instruct the jury as to the two remaining included offenses of reckless homicide, which is defined as, and it gives a statutory definition, and criminally negligent homicide. The court gave the statutory definition. The mens rea of recklessness and criminal negligence are encompassed by the definition of knowing, citing the State versus Eli. And therefore, having concluded that the evidence would have supported a reasonable inference that the defendant knowingly killed Ashley, the victim in that case, we must necessarily conclude that the evidence would have supported a reasonable inference that the defendant acted either recklessly or with criminal negligence. So basically, the Supreme Court of Tennessee said that if the mens rea requirement of knowingly is there, then these other ones fall under it as well. So out of an abundance of caution, Your Honor, because it's a level of review that we're having, the state would like to include those just to make sure that those
You've
are
noted it for the record, fine,
Thank you.
add it.
Thank you.
Count 1, count 2, reckless and criminally negligent homicide.
And then for 3 as well, to also include reckless and criminal negligent homicide.
Okay.
Because it's the same
That's
intentional
what the state
number.
wants.
Yes, Your Honor.
And we all agree.
Yes, Your Honor.
Okay.
Going to count 5, out of the same, going out of the abundance of caution, false imprisonment, although it is lower down there, we are looking at the same reduction of the mens rea requirement. So the state would ask for that instruction to be included as well.
Okay,
Thank you, Your Honor.
add it. You agree?
I agree.
No one opposes what anything Mr. Steele just said.
No, Your Honor.
Well, let's go. But you still need 20 minutes.
Yeah, we're still reviewing over the rest of the language. Thank you.
Not a problem. Recess.
What's that, the recess?
Minutes. You guys want to go to the other one and watch opening statements and then come back to this one? Or do you want to wait? What I was going to say was Dever, whatever her name is, she resigned. Do you think she was forced to resign? Do you think they said, if you don't resign, you're going to get fired? Or do you think she decided on her own to resign? The next trial we're gonna do is in Florida. Deputy shoots girlfriend trial. Dever is the cop from the Karen Reed trial. I think she was forced to resign. I think they said we're gonna fire you if you don't resign. I think that because AJ was like, he wrote the letter that she needed to be put on the Brady list because she's not trustworthy now because she had a false memory. And I think that like didn't the chief of police say that didn't he deny ever having a meeting with her? And she said on the stand she had a meeting with him. Yeah, I think they forced her. I think they did tell her to say that it didn't happen, but I don't know if they told her to say it in that way. Like, because for her to say it was a false memory, that's what ruined her career, because then that makes her not trustworthy. So, but what do you do if you're in that position? Like, either way, I doubt she would have still had a job, because what would have happened if she had honestly said, this is what I saw when she got on the stand? And it's not like, John wasn't a Canton PD officer. John was his officer. And he died. And Karen Reed was accused of killing him. So, of course, he knew who Karen Reed was. So, it was obvious that he was bending the truth. And my husband is so sweet. So, I told him about it, and I'm like, she said that she was told to do the right thing. And Travis goes, so they told her to tell the truth. I'm like, no, honey, that's not what that meant. They meant to protect the officers. That didn't mean tell the truth. Do the right thing meant protect your fellow officers. And he was like, oh. He's just so sweet and so naive and like so honest of I don't know how I got so lucky to get the husband that I did. Like and the man cannot lie. Like I can always tell when he's lying. He's the world's worst liar. Right. Yeah, and I think that's where her problem happened, was she didn't know how to backpedal in a way that made it believable. And the false memory thing is what screwed her over. She screwed herself over, but the false memory thing then made her unreliable. So therefore, her whole future as a cop would become unreliable. So, and then AJ's like, I don't feel sorry for her. I kind of feel sorry for her, because I think that she knew that her job was on the line and she didn't know how to fix it. And she is young. Yeah, and AJ's like, well, she's an adult. Yeah, she's an adult, but I remember, of course, I was more sheltered. I don't know. She could have been just as sheltered as I was. Who knows? I was very sheltered. My mom, and I've told you guys this many times, my mom didn't want me to grow up. So she didn't She didn't teach me how to think like an adult. She didn't teach me how to act like an adult. I was a kid. I was still a kid. Like, you know, I was a nurse. How old was I when I became a nurse? 23, I think. And I still felt like a kid. I felt like a kid playing grown up. And it took me a very, very long time to feel like I was a professional and I knew doing. And I can imagine how she might have felt. So I did feel a little bit sorry for her. But honesty is the best policy. Like, if you tell the truth and then you get in trouble for telling the truth, that's not trouble. I mean, if she got fired for telling the truth, that, to me, that's something to be proud of. If you tell the truth and you're in a job and you get fired for that, then you got fired by somebody that was corrupt. And then you just, you know, wash your hands of it and go on to something else. But in her case, she tried to comply with the people that were corrupt. She should have just told the truth and just said, screw you, and gone on with her life. I think that would have been better for her. But I'm a lot older than her. I've seen a lot more of life, too. So, but yeah, at first, I thought she resigned. And then when I stopped and thought about it, I was like, no, I think they gave her an ultimatum. Because they're getting ready for their closing arguments now. Which usually judges will say, okay, we're going to break for the day and then come back tomorrow for closing arguments. And if she would do that, we could go to the other trial now. But no, I don't know what this judge's deal is. Her time management sucks. Because they could have quit on time yesterday, and then we could have done defense's case in chief today. They could have sent the jury home, and then they could have done the charging conference, and then tomorrow they could have done closing arguments and sent the case to the jury. Like a normal judge would have done. I don't understand her time management plan. It sucks. And you know it's bad when an ADHD person has a better time management plan. That's how the judges usually do it. Okay, state rests. We're going to break for the day. Come back tomorrow to start the defense case. Unless it's like really early in the day. But no, we were at the end of the day when the state rested. And then she goes, how long is your direct going to be? About 45 minutes. How long is your cross going to be? 30 minutes. Okay, we'll stay. What? Good Lord. So they did the charging conference without showing it to us. So that's why we've been sitting here chit-chatting. Now we're sitting here for another 20 minutes waiting while they're finishing up their closing arguments. Instead of letting them go home for the day and work on their closing arguments and then coming back tomorrow, we're just sitting here twiddling our thumbs, as is the jury back in the jury room. I've never seen this done in a trial before. Never been in trial on a Saturday before either. Been doing this for over a year now, and this is the first time I've seen this happen. But that's okay. We will just chit-chat. But I'm running out of things to talk about. And then as soon as it goes to the jury, we will go to this other trial. I should have timed it. Has it been 20 minutes yet? That's what I need. Oh! I have a reason to buy it now. I wonder if it's on DisneyStore.com. In one of the... Where were they? Oh my gosh. I think they were at the Polynesian Resort. There is... At the Polynesian Resort... At Disney... There is it's like a kitchen timer, but it's in the shape of a teacup, like the spinning teacups, you know, like.
Ms. Hughes had previously asked for 20 additional minutes to review the jury instructions. Those instructions have been reviewed. Now, Mr. Massey wants an additional. You want an additional 20. That's perfectly fine, so we'll come back at 11:51. Everyone has an opportunity to review the instructions, make any changes, alert the court, alert the judicial assistant, and we can go on from there, okay? So that's going to be 11:51. No. Yes, let's come back at 11:51, ready to charge and close. If something comes up, you know where to find me. Recess.
Recess. Ian Brown has written it
I did retry that.
So it's like a kitchen timer, but it's a teacup, and the base of the teacup turns to do the timer. So it's like the twirling teacups at Disney, but it's a kitchen timer. And I didn't need it. Now I need it. I need it for my desk so we can time 20 minutes. A bomb threat at Townsend University. Ugh. Good gravy. Why? Lord Jesus, please come back soon. Right now would be preferable. You could come back right now. Right now. I would love it if you could come back right now. Please come back right now. I'm serious. I'm not kidding. Please come back now. Yeah, let me see. I need to see if it's on Disney Store. Because now I really want it. Before I was like, oh, that's cute, but I don't really need it. Now I need it. Wonder what it would be under. Except, no, not accessories. Home? Oh my god. $399. They have it. There it is. There it is. There it is. Add a whirl of fun to your culinary adventures with this Mad Tea Party kitchen timer, a perfect pink replica of a teacup from the beloved Disney park attraction. It makes keeping track of cooking and baking times fun and easy because we all know how time flies, or does it spin? Oh, I don't have to go to Disney. I can order it. Are those minutes or seconds, though? I don't know. I've never had a kitchen timer before. See, look, there's even the little spinny wheel that you spin when you're inside the teacup. That's how they spin. You move the wheel, you do it, you control it. Because some people don't like to, boring people that don't like to spin. Like my husband. He doesn't like to spin. I like to spin. I spin it as fast as it'll go. It's $20. And I want it. I want it so bad. Oh, it goes up to 60 minutes. Okay, cool. He's so cute. And see, like that right there, that's the door where you get in. And then there's a little cutout right there. And it's like a bench seat. You have to scoot over if there's a bunch of people in your party. You have to scoot over because it's a bench seat, but that's where you get in at. And then you turn the little wheel thingy to spin it. But it's a replica of the actual ride. And I need it for my desk so when... Yeah, it is. It goes up. It says it's up to 60 minutes. So when we have a judge that says recess for 20 minutes, I can just take my teacup and then spin it to 20 minutes. I'm gonna have to get me one. Let's see what Halloween stuff they have. Oh, I gotta get a magic band. I have a Mickey hat. It's not like that. But, those things don't stay on your head. They're not, they don't, like, I don't know, maybe I just have a big head. Oh, you can get it personalized. For only $22, that's not bad. That's a little much though for a light up wand. That's not bad for that plush either. $30. What? I wish I had some money right now. This is only $10? This is on sale for $10. It's a $35 ornament. It's Minnie and Mickey on Space Mountain. I want it. That's my favorite ride, y'all. That doesn't look like the Haunted Mansion. What else are we gonna do? We got till 11:51. I want these ears. They're on sale. They're $10 off. Oh, the backpacks, the Maleficent Loungefly's on sale too. I need to get that magic band. I need a new magic band. I need that magic band. These things right here are mystery releases. So you buy this box, you don't know what it is. You can get any one of these things. So my friend's daughter, there's one that has the Hocus Pocus characters, and she bought 3 boxes, wanting to get all 3 of the Sanderson sisters. But she bought all 3 of them at the same store in Disney World, and she got all 3 of the same sister. So the trick is you buy them at different Disney stores, like different stores in the park, or different stores on Disney property, or different Disney stores or whatever, and that's how you get the different ones. So if you ever buy these, I don't understand why you need to get a mystery box. Why can't you buy the ones you want? But I want this magic band. I don't have $45 right now, but I want it. I have an old magic band. The old magic bands don't light up. The new ones light up, and they do things, like things in the park interact with them, and they will light up and play magic. See, here we go again. Play music. And they have these little figurine sets all over the place. I'm assuming those are for children, but they're awfully expensive. This one's not. But it's because it's on the Disney Store website and it's on sale. But these figurine sets, they get up into big figures. Like, so expensive, you don't want to give them to kids to play with because they'll break them. And you pay too much for them. I cannot wait until the new Villains Land. I think they're calling it Villains Land. There's going to be a whole new land added to, because they've got Tomorrowland, Fantasyland, Frontierland. Now they're going to have a Villains Land. I can't wait. It's not going to be done until like 2030 or something like that, but Frank. That's funny. I think the reason why Disney's putting in a Villains Land is because Universal, Epic Universe, the new park, they have, what do they call it? Is it Monsters Land? Monsters Unleashed. No, the ride is Monsters Unleashed. What do they call the land? I forgot what they call it. So I think it's like, because it's, the old Universal monster movies like Frankenstein and Dracula and Creature from the Black Lagoon and The Invisible Man, like remember all the old black and white monster movies from the 30s? Those were all Universal movies. So now Universal at Epic Universe, they have their own land that has all the old original, what you think of as the old original monster movies. And I think that's why Disney is now doing a Villains Land with, their classic villains like Maleficent and the Evil Queen and Gaston and, all of them, Scar, whatever. I don't know what all they're doing, but I'm so excited. Ursula, I'm so excited to see what they're going to do with all that. So, but it's going to be a while. It's going to be like 2030. And then they're also putting in Cars Land, and it's going to be an off-road adventure. So it's going to be kind of a thrill ride, kind of rough and bumpy. And Travis loves off-roading. So that's going to be fun too. We're both really excited about that. So they've already put in a Villains show at Hollywood Studios, which is not the park where Villains Land is going. I don't know if they're going to move the show after Villains Land gets done or not. I don't know. Oh, look at Pain and Panic. They're so cute. Yzma! Is that a loungefly? Yes, it is. Which means it's expensive. That is so cute. Isn't that cute? That is so darn cute. Oh, it has a tail. It has a tail. Oh no. Are those kids? Please tell me those aren't. Please tell me they have those in adult sizes. $11.89. That's probably a kid's shoes. Okay, we got to get back to the trial. They're not back yet, though. There's Maleficent's dragon. Wait, why is a plush dragon $44.99? I like that nightgown. Oh, I like... Oh, wait, that's not a hat. That's those irresistible things. I still don't know why you would want that. It looks like a hat, but it's not a hat. It's just a little dust collector thingy. I want to know, does anybody know the Debbie Broderick trial? Freudian slip there? I see what you really think of me. I want to know why the ones that look like baseball jerseys, why are they $80? I ask this every time I see one of these dang things. Why are baseball jerseys more expensive? Are they made with like gold thread or something? Every single every single time it's a baseball jersey. It's $80. Why? Why are they so expensive? I don't understand. See, there they are. There's those wishable things. You got the three sisters, and you've got the cat, Binks, and the little girl, Danny. So if you get the little box, so if you buy the little boxes, there's the box says you can't have when you open it till after you buy it. And that is what you get. There's a box, and that's what you get. You get one of the 5. Why don't you just let me buy what I want to buy? I don't know. I guess some people like. I don't get it. It says another glorious morning. Where does it say another glorious morning on it? On the back? That looks more like, to me, like it would be a... Oh, that one says another glorious morning. That one doesn't say another glorious morning. I'm confused. Wait, does it... Oh, okay, that's on the back. Sorry that I have what? And this is another one. The Spirit jerseys. What the heck is a Spirit jersey? They're all $80 too. That looks like a long sleeve t-shirt to me. What's a Spirit jersey? Some of them are really, really cute. What? I didn't tell you to do that. Go back. I like that cardigan. That's cute. I like that jacket. Now that's a good price for that jacket. That is too much. That's a good price. I like the... Oh, the ears are on sale too. See, I like the mug. I wouldn't use it to drink out of though. I would... I I like the ornament too. Oh, cool. It lights up. I want the Crocs. And all the Christmas tree ornaments too. I love the Haunted Mansion. It's my second favorite ride. I almost got this. I wanted this. See, it's like my Grogu. They're going over the jury instructions or their closing arguments or something. I wanted to get this, and then I thought, no, because I would only wear it at Halloween. And then I saw Grogu, and I was like, oh, that's it, Grogu. Grogu, Grogu, Grogu. But I think, oh, there's a Zero too. He lights up. The gargoyle lights up. And there's Remy. That from Ratatouille, you know, the rat? Oh, they have joy too. Joy, sadness, anxiety. Oh, cool. Anger. I have a feeling I'm going to have all of the shoulder buddies one day. I'm trying to look for the dress that my friend has. Because I want one. That's probably way there. No, that's not it. Hers doesn't have the collar. I thought she got hers. She might have ordered hers off of Amazon. She must have got hers from Amazon because I don't see it on here. Yeah, that greeting card that he bought for her after he shot Danielle and threw Kennedy in the river, he went to Walgreens and bought that card and wrote in the card how he wanted them all to be a family and he wanted Artesia's daughter to be a good stepsister to Kennedy after Kennedy was already gone. This dude's a POS. So he had a kid with his wife that he still wasn't divorced from, and then Kennedy with this girl. And he didn't have a kid with Artesia, but Artesia had a kid that he was supposedly telling Artesia that he was going to be a good father to all three of these kids. But Artesia, I guess she was okay with Kingston, because in some of the text messages he said that he watched the way she treated Kingston or something. So she apparently was okay with Kingston, but didn't want him to have another kid, which is so not cool. If you love someone, you should love their children too. That's part of them. That child came from them. It's not right. And I mean, yeah, you're gonna have to deal with the mom. That goes along with it, but you do what you have to do. Like, when Travis and I first got married, I had to put up with his ex-wife because he had 2 daughters, and I knew that going in. And I love his kids. I loved his kids then. I love his kids now. I just, now they're grown, so I don't have to deal with her anymore. And I just grinned and bear it for as long as I had to. 6? 6. Who is there's no way these are individual things. Is anybody, is like a group claiming they're doing it, or is anybody, there's no way one, like an individual person for all. I mean, see, this is upsetting me so much I can't talk now. It can't be one individual person per university if it's 6 at once. There's no way that's a coincidence that 6 different people at the same time decided to do a bomb threat. Is there an organization that's claiming they're doing all these bombs? It scares me because of the implications of what this means for the political climate of the world right now, is why it scares me. Do you know which universities it is, Judy? Okay, now I've heard 2 different headlines about something trivial compared to universities, but okay. So Josh Hartnett, the actor Josh Hartnett, is in Canada. I heard there was an accident where he hit a patrol car and the patrolman went to the hospital. Now I'm hearing the opposite, that a patrol car hit him and he's in the hospital. Good Lord. So that's, wait, Maryland, Delaware. So those three are close together, relatively close together. It is 1:11, which is 12:11 there, and they said they would be back at 11:51. Oh, well, that's not close. Alabama A&M. What is happening? Man. Donna Adelson's not getting a new trial. Trying to see if I can find anything about. Oh, Judy, you're fine. I'm just trying to find something about it. I can't. Like a news source, and I'm not seeing anything. I'm seeing stupid crap and nothing about important stuff. Well, I've got the Newsbreak app, and I was expecting to find something on it. And no. I'm getting stupid stuff about how because Florida might be making vaccinations non-mandatory. I keep seeing articles about how everybody's gonna get sick now when they go to Disney World. What the fudge? Oh my god. I don't agree with it myself. I'm a nurse. I believe that vaccinations are a good thing. They got rid of smallpox. I had chickenpox. My stepdaughters did not. They got vaccinated as children. We've talked about this before. But why are people focusing on Disney World? Why do they think everyone's going to get sick when they go to Disney World? And we're talking about children's vaccinations. Babies. There's not an awful lot of babies, infants, at Disney World. Why are we freaking out about getting sick at Disney World? This hasn't even become a thing yet. What the fudge? The world just doesn't make sense anymore, y'all. I want 80s. I want the 80s back. If I could invent a time machine, I would go back to the 80s. And just stay there. And then we got to the end of the 80s, I would get in my machine again and go back to the beginning of the 80s. I would just keep going back. And back. But my point is, just because it's not mandatory doesn't mean that everyone is going to stop vaccinating their children. That's my point. If I had kids, it just means that it's not mandatory. And nobody's saying anything about Universal or Busch Gardens. I mean, we have more than one theme park in Florida. They're all fixated on Disney. This is the most ridiculous day in the world. Why is this happening? We have wasted the entire day, you guys. What have we done today? We've done nothing today. We have heard Mr. POS get up there and say he's not going to testify. Come on, people. Thank you, Judy. Yeah, and y'all have stayed and listened to me ramble, watched me shop. I didn't buy anything. I did shop. I window shopped. I internet window shopped. I want Jill back. Jill had the stomach flu. She hasn't been feeling well. And I miss her. I didn't do that. StreamYard, quit doing stuff. I didn't tell you to do that.
Each litigation team has a copy, including Mr. Isabelle. Anything else we need to take up before the jury returns?
That's correct.
Thank you.
Isn't it with that?
I don't think so.
Oh, it's separate.
I do need this though.
You take it over?
Just over here. I'll take it out when it's done.
134.
Looking for 133.
133.
There it is. Yes, your items.
Go back on the record.
We are on the record. And the jury's coming in. What's,
I want to raise our, judgment of acquittal as a matter of law, and
I asked if there was anything we needed to take up, and I got told that. Just a moment. All right, so Mr. Massey has indicated that he would like to raise what exactly, sir?
Dr. Place, we would raise our motion to judgment of acquittal to each count, that because of the state's proof, we're no longer taking the light most favorable to the state, and ask the court to dismiss first degree murder on each of the 3 counts, counts 1, 2, and 3, and
How is this different from what we did on yesterday? I have here motion for judgment of acquittal approximately 4:38 on yesterday. So we're gonna do both? Okay, so you're asking me to dismiss the first degree. You didn't raise these issues yesterday, so let me start over. Dismiss first degree murder, count 1 of the indictment.
Donna, we are asking that first degree murder be dismissed.
Yes, sir. What else?
And taking the proof of the life equal to most part, it would be second degree there.
She's
not gonna dismiss
first degree murder, dude.
You're asking the court to dismiss count 2 of the indictment
Count 1, yes.
Count
first
1.
degree murder.
and count 2 first degree murder.
Same thing with count 3.
You're asking the court to dismiss count 3 of the indictment, which is the murder and perpetration of a felony.
It should be, when first degree be dismissed and second degree be sent back to the jury.
Would the state like an opportunity to respond?
Yes, Your Honor. Question is whether a rational jury could find the defendant guilty of the indicted offenses as charged. If my understanding correctly, Mr. Massey is asking for not murder 1, but murder 2. Your Honor, the state would rely on previous arguments from yesterday, but specifically addressing Mr. Massey's concern as far as the state has met its burden at this point in time that a rational jury could find the state's proven the case beyond a reasonable doubt. The state would rely on yesterday's statements, as nothing has really changed. The testimony of Dr. Nuschitz from yesterday. With regard to Mr. Massey's point of reducing it to a second-degree murder, the state has put within regard to count 1, which is the first-degree murder premeditated of Danielle Hoyle. The state Tennessee put on proof of that the defendant gave a confession as to shooting and killing Danielle Hoyle at Levi and Sedgwick on February 1st of 2025 here in Memphis, Shelby County, Tennessee. Your Honor, the state has put forth proof as to the element of intent and premeditation based on his search history recovered from his phone, based on his GPS phone location data from earlier in that day, driving out to the area of the crime scene and then turning around and going back out east from the direction in which he came to his home. The state also put on proof of text message conversations and letters that were written between he and Artesia that shows his state of mind at the time. And so the state has put forth proof that a rational jury could reasonably find the defendant guilty beyond a reasonable doubt of first-degree murder of the unlawful killing of Danielle Hoyle. So therefore, Your Honor, the state would ask this court deny defense's motion for judgment of acquittal and sending this case to a jury based on, or reduction of count 1 to second-degree murder, and would ask the court to deny the motion at this time.
I would just raise the same arguments as yesterday in regard to the last 2 counts, which is aggravated child neglect and especially aggravated kidnapping.
With regards to the last 2 counts, Your Honor, aggravated child neglect and especially aggravated kidnapping, the state would rely on its arguments from yesterday, as nothing has changed other than Dr. Newchap's testimony, which the state submits did not negate the intentional elements. Aggravated child neglect, Your Honor, the defendant knowingly neglected Kennedy Hoyle as to adversely affect health and welfare. Statements that through the defendant's confession that Kennedy Hoyle, he stated that he placed Kennedy Hoyle on the riverbank, but later admitted to throwing her by the leg into the Wolf River. Your Honor, that she also was never found. That adversely affected her health and welfare. She is deceased. Even by laying her by the river, that resulted in her dying as well. The act of neglect resulted in serious bodily injury to Kennedy Hoyle, the same points just stated by the state of Tennessee. Also, the Kennedy Hoyle was 8 years of age or less. The state of Tennessee, through testimony of Ms. April Campbell, as well as the baby Kennedy or Kennedy Hoyle's birth certificate, has established that she was less than 8 years old. She was 2 days old. Further proof was also submitted as to the defendant's GPS locations at the time, as well as that put him at Mud Island near the boat ramp, and video evidence also corroborated him as being at other locations at the time his phone says he was, to corroborate that he was with his phone as it was on Mud Island. As to the charge of especially aggravated kidnapping, the state put on proof that the defendant knowingly removed the confined Kennedy Hoyle unlawfully as to interfere substantially with her liberty. The defendant testified that he took baby Kennedy from the back of the vehicle after shooting Danielle Hoyle. He said that in his statement. And he drove with her, I think, for approximately an hour and a half before he admitted to throwing her into the Wolf River. By doing so, he substantially interfered with her liberty. He, at that time, was not a father listed on the birth certificate. He also did not have parental rights at that time as far as that had been established. And so he did not have a legal reason to have baby Kennedy with him, but also taking into consideration the facts that he had just killed Danielle Hoyle based on his statement and the states during the course of the trial. He unlawfully interfered during the course of, she suffered serious bodily injury during the removal confinement. She is deceased as an act that continued during the course of the especially aggravated kidnapping. For those reasons, the state would submit that a rational jury could find the defendant guilty of both of those counts beyond a reasonable doubt, and therefore ask this court to deny defense counsel's motion for judgment of acquittal at this time.
At the conclusion of the state's evidence, the defendant may move, as he has twice now, to ask for the trial judge to consider a judgment of acquittal. When confronted with a motion for judgment of acquittal, the only concern of the trial judge is the legal sufficiency of the evidence and not the weight of the evidence. Respectfully, Mr. Massey, I will have to deny your motion for judgment of acquittal. I do believe that in viewing the evidence provided in the state's case at its best light, it would be inappropriate to dismiss the first-degree murder counts in count 1, 2, and 3 of the indictment, or disturb the indictment on counts 5 and 6. Let's bring in the jury, please.
People in here when we were just hanging out shooting the breeze. Trial starts back when people left.
Judge, in the courtroom.
You may be seated. Ladies and gentlemen of the jury, you may have found yet another packet in your seat. These are your final jury instructions, and I shall read them to you. Members of the jury, the evidence in this case has been completed. It is my duty to instruct you on the rules of law that you must follow and apply in deciding this case. The law applicable to this case is stated in these instructions. It is your duty to consider carefully all of them. The order in which these instructions are given is no indication of their relative importance. These instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each instruction in light of and in harmony with all the others. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law under the direction of the court. You must apply the law to the facts in deciding this case. You should consider all of the evidence in the light of your personal observations and experiences in life. Count 1 and 2 of the indictment charges the defendant with the offense of first-degree murder, premeditated killing. The offense necessarily includes the lesser offenses of second-degree murder, reckless homicide, and criminally negligent homicide. Count 3 of the indictment charges the defendant with the offense of first-degree murder, killing and perpetration of aggravated child neglect. The offense necessarily includes the lesser offenses of second-degree murder, reckless homicide, and criminally negligent homicide. Count 4 in the indictment charges the defendant with the offense of aggravated child neglect. The offense necessarily includes the lesser offenses of child neglect. Count 5 in the indictment charges the defendant with the offense of especially aggravated kidnapping. The offense necessarily includes the lesser offenses of aggravated kidnapping, and false imprisonment. There are 5 counts in this indictment. You are to treat them as separate and distinct at all times. The indictment in this case is the formal written accusation charging the defendant with a crime. It is not evidence against the defendant and does not create any inference of guilt. The law makes it the duty of the court to give in charge to the jury all the law relative to the case on trial. The duty of the jury is to consider carefully all of the evidence delivered to you in the trial and, under the law given you by the court, to render your verdict with absolute impartiality. The jurors are the sole judges of the facts and the law as it applies to the facts in the case. In reaching your verdict, you are to consider the law in connection with the facts. The court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. You shall not have any sympathy or prejudice for or against the defendant or for or against the state of Tennessee, or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think truth and justice dictate. You may consider every fact and circumstance in the case in arriving at your verdict. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with those rulings. My rulings, these instructions, or any other remarks that I have made do not indicate any opinion about the facts of the case or what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements are made that you believe are not supported by the evidence, you shall disregard them. The court will now explain the law applicable to the charge in count 1 of this indictment. First-degree murder, premeditated killing. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Danielle Hoyle, and that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of Danielle Hoyle, and the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, Premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Danielle Hoyle, and that the defendant acted knowingly. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant killed Danielle Hoyle, and that the defendant acted recklessly. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant's conduct resulted in the death of Danielle Hoyle, and that the defendant acted with criminal negligence. The court will now explain the law applicable to the charge in count 2 of this indictment. First-degree murder, premeditated killing. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Kennedy Hoyle, and that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of Kennedy Hoyle, and that the killing was premeditated. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Kennedy Hoyle, and that the defendant acted knowingly. And that was your definition of second-degree murder. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant killed Kennedy Hoyle, and that the defendant acted recklessly. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant's conduct resulted in the death of Kennedy Hoyle, and that the defendant acted with criminal negligence. The court will now explain the law applicable to the charge in count 3 of this indictment. First-degree murder, killing in perpetration of aggravated child neglect. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Kennedy Hoyle, and that the killing was committed in the perpetration of, or the attempt to perpetrate, the alleged aggravated child neglect. That is, that the killing was closely connected to the alleged aggravated child neglect and was not a separate, distinct, and independent event, and that the defendant intended to commit the alleged aggravated child neglect. The essential elements necessary to constitute aggravated child neglect are that the defendant knowingly neglected the child so as to adversely affect the child's health and welfare, and that the act of neglect resulted in serious bodily injury to the child, and that the child was 8 years of age or less. The elements of first-degree murder have already been set out and are previously explained in count 1 and 2 of this indictment. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child neglect. The killing may precede, coincide with, or follow the aggravated child neglect and still be considered as occurring in the perpetration of the aggravated child neglect, so long as there is a connection in time, place, and continuity of action The elements of first-degree murder, second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide have already been set out in our previously explained in count 1 and 2 of this indictment. The court will now explain the law applicable to the charge in count 4 of this indictment. Aggravated child neglect. Any person who commits the offense of aggravated child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly neglected Kennedy Hoyle so as to adversely affect Kennedy Hoyle's health and welfare, and that the act of neglect resulted in serious bodily injury to Kennedy Hoyle, and that Kennedy Hoyle was 8 years of age or less. To constitute neglect, the state must prove beyond a reasonable doubt that there was an actual adverse effect to the child's health and welfare. A mere risk of harm is not sufficient. Neglect is a continuing course of conduct beginning with the first act or omission that causes adverse effects to a child's health and welfare, and can be an act of commission or omission. Child neglect. Any person who commits the offense of child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly neglected Kennedy Hoyle under 18 years of age so as to adversely affect Kennedy Hoyle's health and welfare, and that Kennedy Hoyle was 8 years of age or less. The court will now explain the law applicable to the charge in count 5 of this indictment. Especially aggravated kidnapping. Any person who commits an especially aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly removed or confined Kennedy Hoyle unlawfully so as to interfere substantially with Kennedy Hoyle's liberty, and that Kennedy Hoyle suffered serious bodily injury during the removal or confinement. Aggravated kidnapping. Any person who commits an aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly removed or confined Kennedy Hoyle unlawfully so as to interfere substantially with Kennedy Hoyle's liberty, and that the Kennedy Hoyle suffered serious bodily injury during the removal or confinement. Kidnapping. Any person who commits the offense of kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly removed or confined Kennedy Hoyle unlawfully so as to interfere substantially with Kennedy Hoyle's liberty, and that the removal or confinement was under circumstances that exposed Kennedy Hoyle to substantial risk of bodily injury. False imprisonment. Any person who commits the offense of false imprisonment is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant removed or confined Kennedy Hoyle unlawfully so as to interfere substantially with Kennedy Hoyle's liberty, and that the defendant acted knowingly. As to especially aggravated kidnapping, kidnapping, and false imprisonment, a removal or confinement is unlawful if it is accomplished by force, threat, or fraud, or, in the case of a person who's under the age of 13 or incompetent, if it is accomplished without the consent of a parent, guardian, or other person responsible for the general supervision of the minor's or incompetent's welfare. Although the law requires no specific period time of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find a defendant guilty of this offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offenses of first-degree murder and aggravated child neglect as charged in counts 2, 3, and 4. In making this determination, you may consider all of the relevant facts and circumstances of the case, including but not limited to the following factors: The nature and duration of the alleged victim's removal or confinement by the defendant. Whether the removal or confinement occurred during the commission of the separate offense. Whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. Whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so. Whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not to have succeeded in this objective, and whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm, independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged first-degree murder and aggravated child neglect and was not essentially incidental to it, you must find the defendant not guilty of especially aggravated kidnapping, kidnapping, or false imprisonment. Definitions. Intentionally intended intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances viewed from the accused person's standpoint. Adversely affect the child. Natural effects of starvation or dehydration. Adverse effects on the emotional and mental health and welfare of the child. Child means a person under 18 years of age. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Criminal negligence refers to a person who acts with criminal negligence with respect to the circumstances surrounding that the person's conduct or the result of that conduct when the person ought to be aware of a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Identity. One of the issues in this case is the identification of the defendant as the person who committed the crime. The state has the burden of proving identity beyond a reasonable doubt. Identification testimony is an expression of belief or impression by the witness, and its value may depend on your consideration of several factors. Some of the factors that you may consider are the witness's capacity and opportunity to observe the offender. This includes, among other things, the length of time available for observation, the distance from which the witness observed, the lighting, and whether the person who committed the crime was a prior acquaintance of the witness. The degree of certainty expressed by the witness regarding the identification and the circumstances under which it was made, including whether it is the product of the witness's own recollection. The occasions, if any, on which the witness failed to make an identification of the defendant or made an identification that was inconsistent with the identification, and the occasions, if any, on which the trial was made on the witness made an identification that was consistent with the identification at trial and the circumstances surrounding such identifications. Again, the state has the burden of proving every element of the crime charged, and this burden specifically includes the identity of the defendant as the person who committed the crime for which he is on trial. If, after considering the identification testimony in light of all the proof, you have a reasonable doubt that the defendant is the person who committed the crime, you must find the defendant not guilty. The court further charges you that if you are satisfied from the whole proof in the case, beyond a reasonable doubt, that the defendant, Brandon Isabelle, committed the crimes charged against him, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crimes charged, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of the proof in the case, then you must return a verdict of not guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged, and that it was committed before the finding and returning of the indictment in this case. The burden of proof venue. The burden is upon the state to prove by a preponderance of the evidence that the offense was committed in Shelby County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Shelby County, Tennessee, then you must return a verdict of not guilty. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. You enter upon this investigation with the presumption that the defendant is not guilty of any crime, and this presumption stands as a witness for him unless it is rebutted and overturned by competent and credible proof. It is, therefore, incumbent upon the state, before you can convict the defendant, to establish to your satisfaction beyond a reasonable doubt that the crime charged in the indictment has been committed, that the same was committed within the county of Shelby and the state of Tennessee before the finding of this indictment, and that the defendant committed the crime in such manner that would make him guilty under the law here defined and explained to you. Reasonable doubt is that doubt created by an investigation of all the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Reasonable doubt is a real doubt of the defendant's guilt based upon reason and common sense after a careful and impartial consideration of all the evidence in the case. Proof beyond a reasonable doubt, therefore, is proof of such a convincing nature that you would be willing to rely and act upon it without hesitation in the most important of your own affairs. It is not necessary that the defendant's guilt be proved beyond all possible doubt, because absolute certainty of guilt is not demanded by the law to convict of any criminal charge. But moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. Direct and circumstantial evidence. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of a fact and issue without inference or presumption. Direct evidence might consist of testimony of witnesses who saw or heard what happened firsthand. If witnesses testified about what they saw or heard, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. Circumstantial evidence consists of proof of collateral facts and circumstances, which do not directly prove the fact and issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. The law makes no distinction between the weight you may give to direct or circumstantial evidence.
didn't
Either
hear her
type
say
of
anything
evidence
about it.
can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Impeaching a witness. A witness may be impeached by proving that the witness has made some material statements at some point before the witness testified, which are different with his or her testimony on the witness stand. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, you may consider proof of any prior inconsistent statements only for the purpose of determining whether the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard the evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. Prior consistent statements are admissible to rehabilitate a witness or to respond to impeachment by a prior inconsistent statement. The prior consistent statements cannot be considered by the jury as substantive evidence and is to be used only in assessing the credibility of the witness. Any prior consistent statements can be used only as corroboration of the in-court testimony of the witness after impeachment by opposing counsel. You may consider proof of any prior consistent statements only for whether the witness is telling the truth at trial. The contents of the prior consistent statement are not to be considered as proof in the trial. Expert witness. During the trial, you heard the expert testimony of Officer Brian Onan, who is described to us as an expert in the field of crime scene analysis. You heard the testimony of Special Agent Michael Garner, who is an expert in digital forensics. You heard the testimony of Sergeant Jason Bledsoe, who is an expert in digital forensics and extractions. You heard the testimony of Agent Stephen Walzak, who is an expert in forensic biology. You also heard the testimony of Jeffrey Neuschatz, who is an expert in confessions. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, the witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe the testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different...
Have you forgotten what jury instructions is, Wiggles? She's given jury instructions. Then they're going to do closing after jury instructions.
witnesses, you must reconcile those conflicts if you can, without hastily or rashly concluding that any witness has sworn falsely. For the law presumes that every witness has told the truth. It is your job to decide what the facts of this case are. When you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important you think the witness's testimony was. You do not have to accept or reject everything the witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the question? Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Did the witness have a motive to testify truthfully or testify untruthfully? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently. Witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part which you think is true and ignore the rest. The defendant not testifying. The defendant has not taken the stand to testify as a witness, and you shall place no significance on that fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take a stand in his own behalf, and his election not to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Members of the jury, the court charges you that if any of you have been taking notes in this case, your notes are for your individual use only. You shall not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. Your notes cannot be shown to others, compared or referred to in any way as authority. Your notes can only be used as an aid to your individual memory. No outside communications. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury room. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, or computer, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including, but not limited to, Instagram, Snapchat, Facebook, TikTok, YouTube, Google, or X, formerly referred to as Twitter. To communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. Unanimous verdict. Any verdict you reach in the jury room, whether guilty or not, must be unanimous. Your deliberations will be secret. You will never have to explain your verdict to anyone. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to discuss the case with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself only after a full consideration of the evidence with the other members of the jury. In the course of your deliberations, do not hesitate to re-examine your personal views and change your opinion if convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Having instructed you on the law applicable in this case, the attorneys may now present their closing statements. Pardon me, bench conference.
Yeah, not legally. Not legally. But yeah. How long do you guys think the jury's gonna be out? And in Tennessee, they do sentencing right after a verdict. So, they'll do verdict, and then they'll do the penalty phase like we do for the death penalty in Florida. Only they're not asking for the death penalty for him. With him, it's either, I guess, life without parole. Which I don't know why they didn't ask for the death penalty. Because what he did to me it seems, I don't know, I don't want to say worse than Jose. But yeah, it's worse. I mean, that's a monster. Who throws a baby in a river?
All right, ladies and gentlemen, jury, it's my understanding that someone needs to take a break. I am not going to prevent you from doing that, but I want to direct your attention to page 8. The last full paragraph. There's mention the elements of first degree murder, second degree murder, strike through voluntary manslaughter. That's not what this is. That does not apply. Page 8. And then I need you to fast forward to page 21. We neglected to include Dr. Scott Collier as an expert in forensic pathology. If you may recall, that's when I stopped proceedings and explained to you that he performed autopsies and to prepare yourself. So that's Dr. Scott Collier, C-O-L-L-I-E-R, page 21. That was on the expert list. One of you needs to step away. It is now 1:20. Let's come back at 1:30 for closing arguments.
Ladies and gentlemen, jury leaves pen and pad to the chair.
You still can't discuss the case. I'll let you know when you can. Just leave your packets, leave your things. We'll take care of it. See you in 10 minutes.
What were they doing during the hour that we were doing nothing?
I'm sorry, I don't know where the deputy is. I'll handle that.
The deputy's taking a break, so he's been babysitting the jury because
Recess.
Court stands on recess.
never seen such poor time management in my. This time it's not the judge's fault though. And for me to be complaining about time management, that's bad. When I was an LPN and I worked at the nursing home, every year when the time would change, I would get thrown off schedule so bad. Because at the end of the halls, we had doors that had windows in them. So, I had a watch, but still, I would see the lighting change from the windows. And so then when time changed, I always did my medication pass. We had, so medications, nighttime medications were given at 9 o'clock. We had an hour before and an hour after. So 9 o'clock shift was 3 to 11. So from 10 to 11, that's when I wrapped up everything. Like I did all my charting and made sure that everything was done for the night, made sure anything I'd forgotten got finished and all that. And I usually didn't get out of there till midnight because of all the, paperwork and stuff that needed to be done. All the non-emergent stuff got left at the very end of the night. But at time change, because the light different. Got into the lighting being different. So, which was now, but one of the times I had a schedule for like a week. And the other time change, I would be behind for like a week. Until like it dawned on me that the lighting was different than the time. So I suck at time management. So bad. So for me to be claiming that this judge has poor time management skills, she's bad. I just think she should have done this a little differently. That's all. I would have. I love potato soup. Yeah, I forgot to ask you. Why do you have a hatred for potatoes? You don't like potatoes? Or you don't like peeling potatoes? This is the second lunch I made for myself. This is turkey and baked apples. And it is lean cuisine. The other one was healthy choice, and it was turkey and potatoes. Turkey and potatoes and sweet potatoes and green beans and cranberries, and it was disgusting. So I fed it to the dogs. Belle can eat off a fork very well. Spike not so much. But he's getting better. So I just sat here and fed them one piece at a time, except the green beans. They didn't like the green beans. Well, but Spot does that. Oh, speaking of like the cucumbers, remember I told you, Judy, he doesn't like cucumbers. He tricked me again that one day that I kept telling him he didn't like cucumbers and he ate them. And then the next day he ate them. The third day he started spitting them out again. I had to clean up a mess all over the floor. I don't understand him. He thinks he likes something and he'll eat it for a day or two and then he'll start spitting it out. So next time I tell him he doesn't like cucumbers, he doesn't like cucumbers. I love potatoes. I don't like, okay, I like breakfast potatoes. I don't really care for hash browns. I don't know why. Hash browns and tater tots. And like the hash browns that you get at McDonald's, that's just a giant tater tot. That's not hash browns. I don't know why I don't. It's a texture thing, I guess. But tater tot casserole or like loaded tater tots, I love. And I don't know why, because if it's just a plain tater tot, I don't really care for. It's weird. I know it's weird, but y'all know I'm weird and you love me anyway, so. Oh, I love coleslaw. I don't really put salt on my food. I salt while I cook, but that's one of the things that I won't eat it unless I have enough salt on it. It's just, it's bland without salt. Coleslaw is just, ugh. You gotta put salt on it. I can't eat it without salt. But I love it. But you gotta put salt on it. Potato ice cream? There's no such thing as potato ice cream. Can we please go? We're missing another trial because of you. Potato ice cream. I don't think I'd like that. So I like potato bread. Potato donuts? I don't know. Oh, but I like that potato candy. I'm sorry, that was gross. Maybe do not talk with your mouth full. There is potato candy. There's potato candy that my mom used to make at Christmas, and I have never made it. And I was asking my family about it, and they're like, oh yeah, it's made with potatoes. And I was like, no, I don't think she used potatoes. And they're like, yeah, it's made with potatoes. And someone gave me the recipe, and I was like, oh crap, no way. And so I haven't made it yet, but I'm gonna try it this holiday, probably. This holiday season coming up. Yep, that's exactly what it is. It's good too. And then peanut butter. You flatten it out.
Judge, jury, enter the courtroom.
And you put peanut butter on it and then roll it up, and you make like peanut butter pinwheels with it. Good.
Thank you. You may be seated. Does the state of Tennessee wish to make or give a closing argument?
Yes, Your Honor.
Go ahead, please.
Kennedy Hoyle should be 3 years old. She should be growing, learning, getting into things, driving her mom Danielle and her grandma April crazy. She'd be too big for this car seat, but she's forever frozen in time, not even 2 days old, along with her mother, Danielle. They're gone because of that man, Brandon Isabelle. He shot Danielle 5 times and left her in a ditch. He took baby Kennedy, drove her to the river, and tossed her in the cold, dark water. Ladies and gentlemen, you've heard all the proof that you're going to hear in this case. You've now heard the law given to you by the judge. You have 5 counts, and they're listed up on the screen for you. Now, you'll see in your jury instructions that there are lesser included offenses for each count. That is not a menu. You don't pick and choose. You have to start with the top charge. So in count 1, that'll be first-degree murder. Everyone has to agree that he's not guilty of first-degree murder before you move to a lesser count. Now, let's talk about count 1 and count 2. Talked about in voir dire elements, what the state has to prove beyond a reasonable doubt. You have count 1, which is premeditated first-degree murder as to the death of Danielle Hoyle. You also have count 2, which is premeditated first-degree murder as to the death of Kennedy Hoyle. The elements are the same. First, the state has to prove that Danielle and Kennedy were unlawfully killed, that the defendant acted intentionally, he intended to kill them, and he acted with premeditation. Now, in your jury instructions, intentionally is defined. It wasn't an accident. The defendant, he pointed that gun at Danielle and fired it at her, intending to kill her. He took Kennedy by the leg and threw her into the river. He intended to kill her. Now let's talk about premeditation. You have the full definition in your jury instructions. And you notice that it talks about reflection and judgment, but that there doesn't have to be a specific amount of time with regards to forming the intent of the purpose to kill. So, how did the state for counts 1 and 2 prove premeditation? The planning. Think about everything that you've heard over the course of several days. The defendant, he filed for divorce January 27th of 2022, mere days before he killed Danielle and Kennedy. What else? Kennedy is born January 31st of 2022. The defendant doesn't sign her birth certificate. Then we move to January 30th of 2022. And you heard Special Agent Garner tell you that they went through the defendant's phone And what did they find? Web searches. 2 days out from the murder, and the defendant is searching Jared in the wedding ring section. And then he had some additional searches. Can all bullets be traced back to the exact gun that fired them? Can you tell what gun a bullet came from? Now let's move to February 1st of 2022. And you heard Special Agent Garner tell you that he was able to tell the defendant's movements throughout that day. And earlier that day, he's on Mart Road. And you heard Investigator Byers tell you that Mart Road is along Lakeview. And it's an easy turn to miss in the dark. And if you notice on the map, you take Lakeview and you miss Mart Road, next turn, Sedgwick and Levi. Dark, desolate, deserted. Now the defendant told us in his confession, and his GPS told us, he met Danielle at the MAPCO. And why? He told her he had baby clothes to give her. And what was found in the defendant's white Chevy Malibu? Baby clothes. And then we get to the scene. Levi and Sedgwick. He gets Danielle to meet him at that MAPCO. He convinces her to drive down Levi and Sedgwick. No lights, dark, quiet, raining. And he tells us in his statement that he had car trouble. Think about the scene at Levi and Sedgwick. Danielle's Chevy Cruze parked on the wrong side of the road. And what did the defendant tell us? She got in position to shine her headlights to help him out with his car trouble. And what did he do? He walked up to her Chevy Cruze. He opened the passenger door and he fired. 1, 2, 3, 4, 5 shots into that car, striking Danielle 5 times in the face and head. Premeditation. Now by 9:23, according to his GPS, he's moving on. He's leaving the area of Levi and Sedgwick. And who does he have with him? He has baby Kennedy. And while Kennedy's in the car, and he has left her mother dead in a ditch on the side of the road, he's covering his tracks. He's sending text messages to Danielle, knowing that she'll never answer. Now, he's been driving around for about an hour. Kennedy's been in the car. And he stops off at home to get out of his murder outfit, those Adidas slides, that windbreaker-like jacket, the black and the greenish blue. Takes the time to hang that jacket in the closet. Comes back out, gets back in his car, and what does he do? He drives to Mud Island, all the way from Cordova, passing numerous exits, numerous houses, places. All that time, could have made a different choice. But he went, and he drove on Island Drive to get to Mud Island, to that boat ramp, and he took baby Kennedy by the leg and threw her into the Wolf River. Count 4, we're going a little bit out of order, is aggravated child neglect. And you can see the elements for aggravated child neglect, what the state has to prove beyond a reasonable doubt. That the defendant knowingly neglected Kennedy so as to adversely affect her health and welfare, that it resulted in serious bodily injury, and that Kennedy was 8 years of age or less. And there you have the definition of knowingly, as well as serious bodily injury, all defined in your jury instructions. What did the defendant do with Kennedy? He took in the dark, in the cold, in the rain, out of her car seat. And even if you believe that he didn't throw her in the river, he just left her by the river and she somehow managed to go into the river, he is still guilty of murder and perpetration of aggravated child neglect. Serious bodily injury or death. Adversely affect the health and welfare. He left her where she could fall into the river in the cold, in the dark, and the rain. And as you see, that goes hand in hand with count 3, and that's the murder and perpetration of aggravated child neglect. So in that count, the difference is the defendant didn't have to intend the killing. He had to intend the aggravated child neglect. Last count, especially aggravated kidnapping. You can see the elements. What do we know? The defendant, after shooting her mother, takes Kennedy, takes her from Levi and Sedgwick, drives around Cordova, goes to his parents' house, goes all the way down to the river, and kills her. The state has to prove identity. How do we know that the defendant, Brandon Isabelle, is responsible for each and every one of these crimes? He told us. You listened to his interview with police. He told us. He told us exactly what he did. We have the GPS that Special Agent Garner went through methodically, telling us all the points of where he was located throughout that day and night. His phone, a silent witness to those murders. The text messages. And you'll have those text messages between the defendant and Artesia. They're going back and forth throughout the night. And why is that? Is it because they're in two different locations? They're not together? Then there's the shell casings. The defendant, he told us, he shot Danielle with his 9mm. What do we find? 9mm shell casings in the passenger seat of Danielle's car, 2 in front of her car, and a loaded 9mm magazine in the defendant's white Chevy Malibu in the center console. And he told us what he did with Kennedy. That he took her to the boat ramp, took her by the leg, and threw her into the river. And what did he say in his statement? It didn't go as far as the gun. And what did officers find on that boat ramp? Kennedy's baby cap. Why'd he do it? What's the motive? You'll notice that is not an element that the state has to prove. But it's pretty clear, the motive here. And it's Artesia. The defendant wanted to be with Artesia. You heard her testimony. You've heard the text messages. She didn't want to have to deal with another child on top of her child, on top of the child the defendant already had, another mother in the mix. And so he came up with this plan. And he never wanted that baby. And you can see in that text message that he had sent to Danielle, what does he say? I can't be a father to that kid right now, Danielle. If you love me like you say you do, then let's end our mistake, Danielle. But Danielle wanted to be a mother to that little girl. That little girl wasn't a mistake. Now let's fast forward to January 30th of 2022.
I like that he said it didn't go as far as the gun. I'm answering her right now, Biggles. I like that he said it didn't go as far as the gun. Not Kennedy didn't go as far as the gun, not the baby didn't go as far as the gun, not she didn't go as far as the gun. I think she got that across very well.
You heard the text message.
I liked her opening too. I liked the way she told it like a story when she started off. I don't remember her exact words, but I thought she did really, really good. I like her. She did good with her questions too, but I liked her opening and her closing the best, even better than her questionings.
Is between Artesia and the defendant. And this is in the late night of January 30th. What we know is that Danielle's already at the hospital and she's in labor, about to give birth to baby Kennedy. And what is the defendant texting? He's texting to wifey, Artesia, I love you. Baby, say it back. You doing this to me in a time like this. And what does Artesia respond? Tell her have a safe delivery. I'll talk to you when y'all get the results. Then we move in to those early morning hours, right around the time that Danielle is giving birth to Kennedy. And what is the defendant doing? He's still texting Artesia. He's still sending her messages over and over again. And what is Artesia's response? I'm going to make this simple. If it's yours, build that bond. Get to know her as a woman because she loves you as well. I won't need no response. Silence will answer that for me. If it's not, we still need space to take this relationship slow. She's slipping away. His perfect woman is slipping away. And what does he do? While his baby has just been born, he's still sending text message novels to Artesia, professing his love. And they're still going back and forth. And he says to her, "This is the worst I've acted over a female. Never wanted somebody so bad. You knew this day was coming. Why wait until now and all this love and time?" And then what do? That early morning, after Kennedy is born, they agree to meet up. And where does the defendant suggest? Where you want to meet at? Our river spot? Now we're at February 1st of 2022. 7:58, the defendant gets back to his home on Lathbury. Then he's gone again at 8:05, and he's dressed to kill. According to the GPS data, he's at the MAPCO at 8:32 to 8:51 p.m. And he says that in his statement to Sergeant Lloyd and Sergeant Wimbush. He met Danielle at the MAPCO. And we found the baby clothes in the Malibu. Now we're moving on. Between 9:02 and 9:23, GPS has him at Levi and Sedgwick, and he admits to going there. And during this time, he and Artesia are still going back and forth. And you'll notice that from 9:04 to 9:22, he stops texting Artesia. All those blue messages, Artesia. Green messages, the defendant. And what is he doing in that gap in time, that 9:04 to 9:22? He's shooting Danielle 5 times in the head and the face, and taking her sweet, precious baby and driving away. You see what's left behind. Danielle and those 9mm shell casings. And he drags her, and he tells us how he drags her out of that vehicle by the shirt. And look at her clothes. Look at how her jacket is pulled off her body. He killed Danielle. He left her in a ditch. He's driving around with Kennedy in his seat. He's texting with Artesia, and he takes the time to put in a food order. Cheeseburger, no onions, blue Kool-Aid. And what did Artesia tell us? That she stopped by Dixie Queen that night. And what did we find in her car? Looks a bit like a blue Kool-Aid. Now, we're back at 8702 Lathbury. Gets there at 10:24. You can see what he's wearing. You see those Adidas slides, those black socks. Goes inside, takes the time to hang up his jacket, changes his clothes, and he's gone again at 10:29, holding that blue bag. Baby Kennedy in his white Chevy Malibu. And what did they find in the trunk of that white Chevy Malibu? Those Adidas slides. And looks a bit like that blue bag he was carrying on the ring camera footage. Where's he headed? Island Drive. And how do we know that that's the defendant? You heard Lieutenant Stanley testify that they had license plate reader hits on his tag going over the A.W. Willis Bridge. They were able to look back at camera footage from the Real-Time Crime Center, and they see that white Chevy Malibu driving up and down Island Drive. 10:59 to 11:20. And all that time, from leaving Levi and Sedgwick to 9:23, all the way to Island Drive, could have made a different choice. He had every opportunity to make a different choice. And we're at 10:54, right before he gets to Island Drive, and he's texting with Artisha. And what does he tell her? He tells her he just left the house. But we know he's down on Mud Island, getting rid of the last obstacle between him and Artisha. And at 11:13, right before he takes baby Kennedy and throws her into the river, he wants to know when Artisha's going to be around. 11:20 to 11:27. It's at the boat ramp, GPS. And he says that he threw the baby by the leg. And you'll have his interview. Notice that Sergeant Wimbush, he says he threw the baby by the arm, and it's the defendant that corrects him and says by the leg. Sergeant Boyd asks, how far into the water did you throw her? And his response, it wasn't far. It didn't go as far as the gun.
She said that twice, so she emphasized it.
And now, baby Kennedy is being discovered by Officer Sutton. And what's the defendant doing? He's at Walgreens, buying stuffed animals, roses for Artisha. And writing a card professing his love and talking about raising Kennedy, who he knows he just threw in the Wolf River. And how do we know? Because we have video. We have GPS. And the defendant told us. Now, while we're at the Walgreens, what's going on? texting Artisha. And what did she say? She said he shared his location, which wasn't normal for them. And she called him out on it in the text messages. And where did she say that location was? Walgreens. Is he trying to set up his alibi? Because he's also out there in the parking lot, and you can see it in the video, sits there for a while. And what's happening? Prior to arriving at Walgreens, he's sending text messages. One to Danielle, 11:39. Show me Kennedy. I'm gonna take her tomorrow. After not half an hour before throwing that baby into the Wolf River. 12:02. Give her a kiss for me. Just miss her. That's all. Love y'all.
I don't think so, because she said things like, just leave me alone in the text messages, and she said, if the baby is yours, you need to get to know. She was talking about getting to know Danielle as a person, as a woman, like not as a girlfriend or whatever. I don't remember what her exact words were. So I don't think, like, she did say, like, she didn't want to deal with another kid and another baby mama, but I think because she did say, leave me alone, that, like, she wasn't saying you need to get rid of her so we can be together. It wasn't like that. So I don't think she could be blamed for trying to talk him into doing something like this. So I don't think she has any culpability at all. So yeah, I don't think she's at fault at all.
At 12:13, sends Artisha another text. Now he's on the way to Walmart. And what does he tell Artisha? I want to cuddle tonight. I ain't slept with you in a week. And then we arrive at Walmart. How do we know? GPS, video, and the defendant tells us. And he tells Sergeant Wimbush and Sergeant Boyd. He left the car seat at the Walmart. And Officer Blake, that's where he finds it. And what does he find? Finds the car seat. And then you heard from Officer Walker, a mitten. A matching set. The riverbank and Walmart.
How did I miss the mitten? Oh my god. I don't remember the part about the mitten. Oh, that's sad.
Then he goes to Stacy Road. And again, his GPS puts him there. Artisha puts him there. He's coordinating meeting up with her. And what is found in his Chevy Malibu? An empty gun holster, a 9mm magazine, and gloves with the cockleburr. And then by 1:07 a.m., he and Artisha are back at his house at Lathbury. Let's talk about the gun. There's been a lot of talk about Artisha had a .40 and a Smith & Wesson, and there was .40 caliber rounds found at Levi and Sedgwick. You saw how many rounds were found of various calibers at Sedgwick. You saw, when you zoomed into that picture, that street sign that was covered in bullet holes. You heard Investigator Byers' video, and he said that jingling noise that you could hear were shell casings. But what shell casings were found in Danielle's passenger seat? 9mm. What shell casings were found just up from the car? 9mm. What magazine was found in the defendant's center console of his white Chevy Malibu? 9mm. And if you look closely, from in front of the Chevy Cruze, Hornady, shell casing. In the passenger side of Danielle's vehicle, Hornady 9mm shell casing. And in the defendant's car, live rounds, Hornady 9mm. And what did the defendant tell us he did with the gun? He threw it in the river. What did we find? We didn't find the gun, but we found his gun box. And what was in that? More magazines for a 9mm. What gun did we find? We found Artisha's gun, a .40 Smith & Wesson. It wasn't missing. It was right there. And then you look at the scene at Levi and Sedgwick, and you can see, and those are placards 12 and 13, those are those two shell casings from a 9mm in their Hornady brand. And what did the defendant tell us in his statement about what happened? After he shot Danielle, the car rolled. And you can see a pile of glass fairly close to those 9mm shell casings. And you can see Danielle's car in the distance, as if it rolled. Now, at one point, the defendant tells investigators, after he's had some time to reflect, oh, Danielle was an accident. Ladies and gentlemen, you heard Dr. Collier. Danielle was shot 5 times. In the head and in the face. This was not an accident. This was a premeditated execution. Then we have the DNA, the Adidas slide, seen on the defendant that night in that Ring camera video, found in the trunk of his white Chevy Malibu. And what did he tell officers about that during the interview? He said that Danielle's blood would be on the slides. He even specified which one, the left. And which one had Danielle's DNA, according to Agent Walzak? The left. And then he sits through that interview the entire time wearing those white socks with Danielle's blood on them. And you saw that he had a pair of black socks over them. And that blood had seeped through to those white socks. But Officer Carlisle found them. They went to the TBI to be tested, and once again, Danielle's blood on those socks that were on the defendant's feet. Ladies and gentlemen, the term victim is used a lot. But Danielle and Kennedy were more than that. Danielle was a mom. She was 27 years old. She was a girl mom. She had 9-year-old Jariah and her new baby, Kennedy. And then there's Kennedy, who will forever be, frozen in time, less than 2 days old, never getting the chance to grow up. Danielle's mistake was getting involved with that man. Danielle and Kennedy. They'll never do so many things. And it's because of what the defendant, Brandon Isabelle, did. Ladies and gentlemen, the state asks that you find the defendant guilty of every single charge of the indictment. Thank you.
Does the defense wish to give a closing argument?
Yes, Your Honor.
Go ahead, please.
Great. Great call.
Good afternoon. A long journey. Not always pleasant. Counsel laid out a lot of facts. You did a very good job of it. But I want to ask you this, and I think this is where your concentration would be, particularly count 1 and 2, which are the premeditated murder charges. And that is whether these acts were premeditated. That's the difference between first degree and second degree murder. To be premeditated, and that's one of the elements that the state has to prove beyond a reasonable doubt. To be premeditated, the court told you, and it's a short instruction, so I'm going to repeat it here. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act, before the shooting, before the baby, before throwing the baby. It's not necessary that the purpose to kill pre-exist in the mind of the accused for any different definite period of time. This is where I want you to look. The mental state is on page 4 of the jury instruction. The mental state of the accused at the time he decided to kill. Midway of the page. The mental state of the accused at the time he allegedly decided to kill must be carefully considered. in order to determine whether the accused, whether Brandon, was sufficiently free of excitement and passion. So as to be capable of premeditation. Because that requires reflection, cool thinking, reflection, judgment. So the state has to show that he's sufficiently free of excitement and passion.
He had 9 months to decide
Now,
on Judy, or however long he knew she was
I'm reading
pregnant.
this over. I also looked at the next sentence, and it says, if the design to kill was formed with premeditation, it doesn't matter if they were acting in a state of passion when they acted. Well, I ask you this. Is there any evidence anywhere that you've heard throughout this entire proceeding that Brandon was thinking about taking the lives of Danielle or that baby? Oh, it's the started hers. There's not. There's no plan that he was going to kill that child or Danielle. Why? What in the world? What drove him? That's where we moved our teacher. Can there be any doubt from what we've heard and even from the state's argument that he was head over heels in love with her? That's bad. Head over heels in love with her. And what would she do? How would she, I mean, let's look at this situation. What we've got is Brandon and Artisha over here, and they're a hot couple. And you've got Danielle and the baby over here. Now, Artisha does not want him around Danielle. She says she's a nobody. It's the baby. And you told me it's not yours. She wants him for herself. And she even says in her statements that she's a narcissist. She wants him to herself. And I respectfully say, to me, and I hope to you, that she manipulated him. She tortured him. It's love. And I'll show you why I say that. And she pushed him. She drove him. She wanted him more than anything in the world, rightly or wrongly. He loved her. You can't reason with love. You just can't. Go through a few of these. It's a big stack. It is full of what I'm telling you. I pulled out some of the larger pieces. Okay? It is full, please read through it and consider what I'm telling you. On the 30th, at almost midnight, he had texted her, Brandon had texted her, I love you. And she sent an emoji for the heart. And it's got love. And he says, you text there, but you can't say you love me back. what would she do here? Now, let's look at the time we're at. With the day before the baby's delivered. With the day before. So their relationship is strained. And he's going to the hospital. And she just says, when he says, you can't say you love me back, she just says, get there safe to the hospital, get there safely. Wow. Good night. He says, you're doing this to me in a time like this. In order to have a safe delivery. I'll talk to you when y'all get the results. What results is he talking about? The DNA. The DNA results. Because Brandon's told her all this time, I'll be out here. She's wanting to know what the results are going to be. I'll talk to you when you get the results. But she goes through. She says, let me know the results. My stomach hurts, so this relationship is at stake. Now to Brandon, that's shaking his world, because he is in love with Artesia. He's smitten with Artesia. And she knows it. And so he texts her and says, look, do you want this or not? You want to be with me or no? And her response is no or no. I think she's gonna be in the way. To me, I submit to you, that's an important statement there on. That's an important statement there on page 11. I think she's fixing to be in the way. What's she getting at? I'm not saying it. What's she getting at? If she goes further, I'm going to make this simple. If it's yours, build that bond. Get to know her as a woman, because she loves you as well. I won't need no response. Silas will answer that for me. We still need this. We still need space to take this relationship slow. And talking about the birth certificate, sign it if it's yours. If it's yours, sign. Don't call me. Don't call me if it's yours. That's what she's told me. Then we get to that long statement of Brandon's where he's just basically pouring out himself to her. And this is on January 31st at 3:48. That's when the baby's delivered. I really want to say this to your effing face. No emojis needed this time. Look, I up and love you, Artesia Lachey Isabelle. Call her by his last name. Of course, likes her as white. I love you and only you. You meant the world to me, baby. I want to say this to your face. No tears needed, because I want you to understand where this is coming from, my heart. This makes me look at women different. When I got with you and found out when I got with you and found out about this situation, I know it makes you look dumb to the world for being with a dude with a baby on the way. But I heard the same thing from people when you were pregnant. People were saying it was my baby. How do I feel? Why am I with someone else's baby mama having sex, etc.? But I tuned it out because I knew what I wanted eventually. It may have took me a long time to make the move, but that's only because I know how my heart is, as you have clearly seen twice. When I love hard, and it breaks me down to let somebody that's my world leave me.
This is not a closing statement. He is just rereading the text messages from the trial.
I visioned it long before us. I envisioned it being us five together. And I respectfully submit to you what he's talking about is him and Artesia. Artesia's child, Olivia. Kingston, his one child, and the baby. Like I've talked, five of us together, and I've talked to Denisha about it. Kingston being the oldest and the brother to protect his two little sisters. Me and Kingston being the men of the house to protect our three queens. Me and Kingston will forever have y'all. I will continue to teach him to be a gentleman, to hold doors to women, what side of the sidewalk to walk on, etc. Us five, nothing can defeat us. I'll have either full custody of Kingston or joint, so it won't be any, there won't be any he can't come around. She'll have to deal with it, but that's how, I'm so little. She'll have to deal with it. How I have. But that's nothing I have to explain to her. She might have my son because of court orders. And Danielle, time will tell. This was on the 31st. Time will tell, but if you're willing to talk to her like you say you are, then maybe that'll be a good start to something special for us and for the baby. I would say talk to Danielle. She might be reasonable. Maria, I wouldn't advise anybody to talk to her. And as I sat there, I thought about all this. I would want somebody by my side to be a great stepmom and even a greater mother. I love when Kingston smiles at you and plays with you. It warms my heart. My dad even asked me that before. You like that, don't you? I said yes. I hope you can look at the baby like that. I want to be able to call you later down the line and say, while he's at work, check on you, and you say, oh no, babe, me and the girls are just going shopping. Or me and the kids just ran to Walmart or something. I want to see Aaliyah having a stepsister and eventually play with it and talk with it and hang with us in later years. All of these things are what I want. And why not want them with the love of my life? You are where my heart is. You are home. You don't have to respond. I know your mind is everywhere, baby. I understand. Just continue to read this over and know this is real and live. I'll give you your time again. I love you. Good night. Whether he should have been or not, Brandon Isabelle was ever revealed to love the Lord Jesus. And what did those pieces say that pouring out of his heart? He said, just take care of your children, Brandon. That's what they're talking about, is breaking this relationship up, because she doesn't know if she wants to be in this situation. She's got a baby with Serena in Houston. He's got a baby with Danielle, and he's in love with her. But she doesn't know. She's in love with him. That's her. She didn't know she was to step into that situation, because everybody who's heard or knows that it can be a situation at times. She doesn't know if she wants to go there. So she says, just take care of your children, Brandon. She's not responding to the confession of love that he's poured out. She says, don't want to look any dumber. I got my answer. I don't hate you, but that's the man you are. And thank you for the journey, and I pray for this. And it gets worse and worse for a reason. Love isn't my best favor. I just hope everything works out for y'all. Because she's playing now. When you go to Danielle, everything will work out for y'all. It'll be okay, knowing that he is in love with her. And yes, she's a good woman. She can help you through a lot. Just give her a chance. For me, this is my last message. He said, well, what do you mean, the man I am? What's that? You knew all the time. Sure, baby? But can you please leave me alone? Please leave me alone. And then she keeps writing. How many pounds? What's her full name? Answer my question. What's her full name? She says, if it's yours, I don't want to talk to you anymore. You want to be with her, Danielle. And he's saying, no, I don't. I want to be with you. I don't want to be with her. And she goes with the kind of reverse psychology again. I'm trying to get y'all to be a family. Y'all work it out. I regret this. You don't have to come back and get nothing. Delete my mom's number, just everything. Pictures, burn it. all. I don't want to remember none of this. Why are you doing this to me at times like this?
I'm starring these
And
comments so
that's
we can
what
talk
God
about them
said.
during
I'm
deliberation.
hurt. I'm very hurt. I just want to cry and be held. And then she comes back. She says, I love you, babe. I love you, babe. He said, I love you too. And then we go right back. I'm afraid we're not fixing to be the same. Why? Why are they not going to be the same? It doesn't take a lot of deep thought to get there. The baby and Danielle. Is Brandon saying this? He wants her to learn to be a good stepmom and a good mother. How are we going to make it work? I'm trying my best. This is hard. What? I'm trying my best in this situation. Talking to her like I'm supposed to feel about my so-called man in the hospital hours. I hate this for me. But this ain't doing nothing but building a wall. You expect me to be loving in a situation like this. I'm all over the place. Danielle. Patricia. This is where you have hospital. And she's not good on the 31st. And she tells him, I've been trying to prepare, but I wasn't fully prepared for this situation. I'm sorry. I'm selfish. And she tells him about the paternity test. I want those paternity tests. We'll talk after the paternity test. The DNA, I'll go by and bring it to you. Remember the law agrees which we done about the DNA test. You swab her, you swab the baby, and get it back to me. I just don't want you getting too close to it. And she's not yours. And again, what's her last name? What's her last name? After 4:30 in the morning, I feel you will leave me for them. Our relationship is at stake, even on mine. And she starts, you don't intend to leave her, do you? You don't intend to leave her. I'd rather you get away from someone as worse as you. I'm a narcissist. It's somebody that loves themselves, looks after themselves. This is all for, I hope, I beg you to. I don't want to do this anymore. Goodbye. claimed all this time you want me and miss me, and then you push me back like this. I've never been hurt in my life like this. We don't need to even be or even deal with each other. Thanks. Be blessed. Give me 1 second. I'll go to the next. You stay at the hospital, Brandon, or you go home, but you can't come here. We just can't be together, I'm sorry. It's like you making this situation heavy on me. My heart never felt like this, and my mind has never throbbed like this. We just need to leave each other alone. I love you. We just need to leave each other alone. I want you, but we just need to leave each other alone. Let's play. Together away. I'd rather be alone. That's how I've been lately. And on, and on, and on. So, I ask you say beyond a reasonable doubt that Brandon was not driven by passion? Would you mind resting for me?
Your Honor, you approach.
Pardon me.
I don't know. Ashley Benefield verdict came in around midnight. I fought that on the lawyers. It didn't tell them they could come home and come back the next day. And it was a compromise verdict. A poor woman. I don't think she should have got any prison time, but they got a compromise verdict because they wanted to go home. And I think the lawyer should have said, you know, you can go home and come back and finish tomorrow. Nobody told him that, and they midnight. She got second-degree murder. I don't think Artesia should be blamed, because Artesia didn't say get rid of them. Do something to get rid of them, get them out of your life. I don't want to have anything to do with them. She said, if the baby is yours, I don't want to ever talk to you again. She said, you need to take responsibility. If that's your baby, you need to get to know her. She didn't say, I love you and I want to be with you, get rid of that baby. So I don't think she should be blamed.
In your mind, rest easily as to the state establishing provocation beyond reasonable doubt. Teacher, get away from Danielle. Prove the baby isn't here. Get a test. Don't come back to me till it's done.
I don't disagree with that.
It's yours. I'm not talking to you anymore. carefully examine what your jury instructions tell you. Carefully examine the mental state of Brandon Isabelle. Regarding count 5, which is especially aggravated kidnapping, under the state's theory, Brandon took the child after shooting Danielle, took it with him. He kidnapped her at that point. Just say. Here's what the jury instructions say. Unless you find beyond a reasonable faith certainty, unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish a first-degree murder and aggravated child neglect, and was not simply incidental to it, a part of it, then you must find the defendant not guilty of the sex aggravated robbery. I respectfully submit when you remove premeditation, that leaves you with second degree. I think and submit to you that's what the state's proof has shown you. And to reach a verdict, you have to be unanimous. That's true. But you don't have to reach a verdict if you can't agree. You only reach a verdict if you agree. If you don't agree, you see if you try to work it out. If you can't, you don't agree. You ain't got a verdict. To have a verdict and return a verdict, it must be a unanimous 12 people agreeing. I just wanted to be sure everyone understood that. Always talk to your fellow jurors. Keep an open mind, but do not give up your own belief, your own conviction, simply to lift the verdict or because other jurors think differently. Be strong. All right. Thank you.
Does the state wish to give a rebuttal argument at this time?
Yes, Your Honor.
Go ahead, please.
Thank you, Judge. I got to clear something up real quick, because when you look at the premeditation jury instruction, passion in there does not mean that because you're in love with someone and they don't love you back, you can go start killing people. That's not what that means. That is a passion that's born of provocation. Somebody does something real bad to you. You know, somebody beating on your kid and you just lose it and you kill them. You come home and your spouse is cheating on you, so you kill somebody because of that. That is the passion. It's born of provocation. Not oh, I love Artesia so much. I think I'm going to go kill a bunch of people that are in the way. That's not what it contemplates. Anger, rage, sudden excitement, that sort of thing is what that contemplates. And I want to talk about, I thought that he didn't mention Neuschatz at all, and I guess it makes sense because that guy didn't even look at the facts of the case. He didn't mention the idea of a false confession. He forgot about that because obviously it's not a false confession. But I want to take you back just a little bit to go to this premeditation idea, right? Where did the defendant start his day? What did he say in his statement? He was at Regional 1. You remember that? He went to Regional 1. Why was he at Regional 1? What was he doing at Regional 1? That's where Kennedy was being born. Why is he there? This guy hasn't been paying any attention to Danielle for months. We know, based on the prior text, that he doesn't even want the baby. So why? Why is Brandon Isabelle at Regional 1? To try to take down Danielle's defenses. He doesn't care about that baby. He doesn't want that baby. But he's planning on killing that baby. That's what he's doing up there. He didn't go to Regional 1 because he loves Kennedy. Because if he loves Kennedy, he wouldn't have thrown Kennedy in the river. He didn't go up to Regional 1 because he loves Danielle. Because if he loved Danielle, he wouldn't have shot her in the head 5 times. That's planning, ladies and gentlemen. And again, forget about that definition he was giving you of passion, because that's not the definition for passion. That is planning. It's premeditation. What does he do the rest of the day? He goes to the surgery center for his kids, and he goes home to Lathbury. Now think about this. He goes home to Lathbury. It's just later on that day. And we see him going into Lathbury. It's about 7:58. What's he wearing? He's wearing those slides. He comes right back out of Lathbury, and he has done what? He's done what? He has lured Danielle to the MAPCO. His heart isn't just filled with love for Artesia. He wants to kill Danielle. That's why he lures her to the MAPCO. Long time goes by. He drives all the way to MAPCO, and we have his GPS taking him all the way to MAPCO. What else do we have? We have text messages between him and Artesia. And what's Artesia saying? Who can blame Artesia for not wanting to be with a guy that's having a baby with another woman? That's kind of normal, right? But is she texting him going, yeah, kill, kill, kill. You're not going to have me unless you wipe out these people. No, she's just texting normal things. They're planning on going out and have dinner in those texts. She went and bought him food from Dixie Queen. There's none of that kind of madness right there. They're just having normal conversations. It's up, it's down, it's in. You know, they're on the rocks. Seems like maybe a toxic relationship, but she's not inspiring him or encouraging him to kill anybody. I mean, we know he's on the scene. He gets her, and think about his statement too, and his statement is corroborated by all the proof, but he lures her to the scene at Levi and Sedgwick, right? What's going on there? It's a dark scene. We know he already cased the place because he went to Mart Road earlier in the day. That day, he went to Mart Road. Mart Road is just like Levi and Sedgwick. It's right next to Levi and Sedgwick. And he lures her out there, says his car's messing up. His car's not messing up. He gets her out there, and he's got his gun with him. He has his 9mm gun with him. Why? Why in the world would he lure Danielle out and bring his gun with him? That's weird. Seems like maybe he had a plan to kill Danielle. And he gets her out there, and he shoots her 5 times. 5 times in the head. No, we can just skip that one. He shoots her 5 times in the head. Car rolls back. It's pretty obvious he's the one that shot her, right? They didn't even argue against that. 9mm Hanaday rounds laying on the ground, pile of glass, car rolls back. Just like he said, remember, he's the first one that said that. He's the first one that said he used 9mm. He's the first one that said he shot her, and the car rolls back 20, 30 feet. What does he say he does?
Patrick Brown, Organized Crime Division.
What does he say he does? He pulls Danielle out of the car, pulls her body out. What kind of passion is that?
Turn it off.
He's just trying to get rid of the body, right? He grabs Kennedy and does what? Puts her in his car. Is that okay? What's that? That's kidnapping. He had no right to take Kennedy and put her in his car after he killed the mother. It's not passion, that's planning. That's planning. He brought the bullets with him, he brought the gun with him, and he aimed it right at her head, and he fired it 5 times. That's premeditation. It's premeditation. Now, the inspiration is Artesia. He's worried about losing Artesia. That's why he killed her, but it's not because of some passion. He planned it. He planned it for days. What is it? What happened? How about the Google search, right? He's searching on Google about whether or not shell casings can be traced back to a gun. Was it a passionate Google search? No. He sat there and he typed in the words, and he searched, and he found out, probably, yeah, they can trace guns back to bullets. And what does he do with the gun? He throws the gun away. Passion? No, that's planning. That's planning to get away with the murder. So what does he do with the baby? What does he do with baby Kennedy? He's planning on how to get rid of, he's trying to figure out how to get rid of baby Kennedy. Trying to figure out, how can I get rid of this baby? What can I do with this baby? He said in his statement, I got to kill that baby because I didn't want to be a single parent. Yeah, the baby's in the way. Baby Kennedy's in the way. But he knew what he was going to do because he drove all the way out there, 30-minute drive all the way out to Laughberry. And what's he wearing when he walks in the door at Laughberry at about 10:04 p.m.? He's wearing the murder slides. The slides with Danielle's blood on them. He's wearing them when he walks in. He's not wearing them when he walks out because he put them in a bag, and he put his murder clothes in a bag, and he put them in the trunk of his car so as to hide it, so nobody could find it. That's planning. Maybe not the best planning, but it's definitely planning. He goes all the way down to Mud Island. Is that a passionate killing, or is that a long bit of planning on how he's going to get rid of that baby? Drives all the way down to Mud Island. Now he's had the baby for, I don't know, an hour or so. Is he still killing the baby because of the undying love that he has for Artisha? Just some passion? You know, he's planning to kill the baby. He's planning. He's trying to figure out, what am I going to do with this baby? Because we see his car go over A.W. Willis Bridge, photograph of his tag. We see the white Chevy Malibu driving up and down Island Drive, looking, searching. Where am I going to dump the baby? Where am I going to get rid of this baby? How am I going to kill this baby? And again, why did he throw the gun in the river? That's planning. He told them that those Adidas slides that he had on had her blood on it, had Danielle's blood on them. What did they have on them? Danielle's blood. That's corroboration for his statement. What else did he have on that whole time? The whole time during that interview. Remember what he had on his feet. He had those socks on his feet. Hours into the interview. After they brought him down to the river and he's pointing out where he left the baby, he had the socks on with what? With Danielle's blood on them. He had the black socks pulled up over him. He said he threw baby Kennedy in the river. And we found her hat right down there by the river. Some hour and a half after he kidnapped her from the scene where he killed her mother. What does he do after he kills her? He runs to Walgreens. Or he drives to Walgreens. And we know he drives to Walgreens because we have his GPS, and he gets at Walgreens and we see the video of his car circling around Walgreens, and he backs his car in and he goes inside Walgreens and he buys some things. He buys rose for Artisha. And he buys a card. Remember what the card said? What did the card say? Dear Artisha, dear Cookie, whatever, we're going to raise Kennedy together. We're going to raise the baby I just threw in the river together. Love, Brandon. What else is he doing though? At 12:06, around midnight, when he gets to Walgreens. And remember 12:06. Remember what's happening at 12:06? 12:06 was the very time, the very minute that Danielle Hoyle was declared dead. She's been sitting in a ditch all this time with her blood soaking in with the water running down the ditch. And a paramedic has finally declared her dead at 12:06. And at that very minute, what is this guy doing? He's sitting in his car at the Walgreens parking lot. What's he doing in the car? Writing a little love note to Cookie. What else is he doing in the car? He's writing texts, sending texts to who? to Danielle. Kiss the baby for me. Well, I guess you're asleep. That's diabolical. That is diabolical planning is what that is. Absolutely. Setting up his alibi. Sending text messages to the woman who he just fired 5 shots into her head, talking about the baby that he just threw in the river. But then what does he do? Got to get rid of some more evidence, right? Jumps in his car. GPS's his way right on down to Walmart. We see him on the video. The familiar Chevy, the familiar car he's driving. Chevy Malibu. We see a figure get out and drop off what turns out to be the car seat. The car seat. The last known refuge. The last little piece of comfort that baby Kennedy had before he pulled her out of it. So yeah, his motive was to kill these people, to kill Kennedy, and to...
Yeah, he said it in the text messages. He said that he might even get full custody of Kennedy and that they could raise her together. He's an idiot.
Kill Danielle so he could clear the deck.
And that was after he'd already thrown her in the river.
So he could be with Artesia. But he's not under any kind of passion. He's not under any kind of provocation. That's just his plan. That's just what he needs to do, what he feels like he needs to do.
Card. He said that in the card. Yeah. He said that they would raise Kingston, Kennedy, and her kid. Yeah. He's an idiot. He is dumbass central. Yeah. He's just beyond stupid.
I want y'all to think about Kennedy, okay? Kennedy, sitting down there by the river. Kennedy, 45 hours old. And he puts her down there by the river. And she can't walk, right? She's not in that when he puts her down in the river. She can't walk. She can't swim. She can't hold her head up. She can't make a phone call. She's just left down there by the river. What she needed at that moment was what? She needed a blanket. She needed a car seat. She needed April. She needed the beautiful family that he just lured her away from, that had just showered that little baby with love for the hour that they had her. That's what she needed. That's what Kennedy needed. What did she get? She got lured away by this guy who was planning to kill her. She got lured away by him. What else did she get? She got dragged down to Levi and Sedgwick, and you've seen Levi and Sedgwick. That ain't no place for a baby. What else did she get? She had to sit in that car a foot or two away from 5 gunshots. 5 loud gunshots that must have already subject to 5 gunshots 2 feet from her head. Most of us live our whole lives without having experienced that. But that's not all she got. She got to watch those bullets enter the head and neck of her mother that had just given birth to her. What else did she get? She got to watch this guy drag her mother out of the car and throw her on the side of the road like a piece of garbage. But that's not all. What else did she get?
What?
Pardon me. I'll be right with you.
He did nothing improper. He did not do anything improper. Why are you objecting? There are some things you can't say. You can't misstate the law. You can't play on the jury's sympathies. I don't think that was playing on the jury's sympathies, though. That might have been why he objected, but I don't think that. I don't think.
Mr. Christensen, I hate to interrupt your closing any more than it already has been.
Thank you, Judge.
But I've been asked to take a break. I want to go to your withdrawal.
Good
So,
God!
I'm happy to bring them back so that you can finish, but I don't know what their needs are. I don't know if it's a bio break, I don't know if it's a medication break, but I have to give them a
Oh, yes,
break.
ma'am. No, I don't want to.
But I don't want to take it away from you, so do you mind if we take a 2-minute break for the jury?
Not at all.
Ladies and gentlemen, you are not to discuss anything. The deliberations have not begun, and if there are any statements that have been made that are inflammatory that you do not believe the evidence supports, you shall give it no weight. Excuse. See you in a bit.
Step.
Then to discuss amongst yourselves when you want to eat.
That might have been why he objected. That might have been. He might have thought he was playing on the jury's sympathies too much. Because you can't... Okay, they're my favorite law movie of all time. I've never, ever heard a lawyer talk about this movie. You're not supposed to play on the jury's sympathies. And my favorite law movie does this in the most egregious way. And it's why it's my favorite. And when I learned that you weren't allowed to do this, I was like, well, dang. I guess this closing argument wouldn't work in real life. It's A Time to Kill. It's Samuel L. Jackson and Matthew McConaughey. And it's set in Mississippi, maybe? I think Kevin Spacey's in it, too. I think he's the prosecutor. And Matthew McConaughey is the defense. And Samuel L. Jackson's on trial. What happened? Samuel L. Jackson's little girl was going to the store, and these two white guys beat her up, essayed her, and I don't remember what all else, but she ended up in the hospital. She almost died, but she lived. And he snuck into the courthouse and hid in a closet or something. And when they were going to, I guess it was their arraignment, like their first hearing, he jumped out of the closet and he shot both of them. So Matthew McConaughey, Sandra Bullock's in it too. Yeah, there's a book by John Grisham. I loved the book, and then when the movie came out, I was like, oh, I have to see this movie. So, he does the closing argument, and he basically is giving the facts of the case. Imagine this little girl and what was done to her. And he does the whole, like, everything that was done to this little girl. He even tells the jury to close their eyes, I believe, if I remember correctly. So he does the whole thing, every little thing that happened to her. And then he says, he pauses and he says, now imagine she's white. I get goosebumps just thinking about it. And he got him off for killing those two white rednecks that almost killed. Yeah. It was. I've got goosebumps just thinking about it. It was the most amazing closing argument I've ever heard. And yes, it was Hollywood, and John Grisham wrote it, and I mean John Grisham is a lawyer, and he writes all these unrealistic law movies, but still, Yeah, I've got goosebumps just talking about it. And then I find out, no, you can't do that. And I've never heard a lawyer talk about that. I would love to ask someone about it. Could you really do that? But that movie was so good. And then at the end of the movie, because like, and then Samuel L. Jackson, I don't remember the character's name, but anyways, he's like, but you wouldn't come around to my house. You wouldn't come sit down and have dinner with me. And that one I haven't seen. I've been wanting to see it. I just haven't done it. I think I have the book too, but I haven't read it yet. I don't know why I haven't read it yet, but I have a bad habit of collecting books and not reading them. But anyway, he's like, you wouldn't have nothing to do with me. You just defended me because it's your job and blah, 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 whatever. So at the very end of the movie, after he gets him off, he goes and they have this big party and he shows up and he brings food for the party and his kids play with the little girl and it's a great movie. It is such a great movie. I love it. It's one of my favorite movies. In fact, it's time for a rewatch. I haven't watched it in a long time. I've been wanting to watch it. I just have not watched it yet. I don't know why. But Matt Damon, is it Matt Damon that's in that one and Danny DeVito? Is that Runaway Joy? So what? Let me see. Hold up. Who did we just watch? Jose, right? I just lost my train of thought. Yeah. Yeah, I did too. That is such a good movie. So, in the Jose Soto Escalera trial, Rob told me something that I didn't know. Lon Lumber, because I watched him react to the closing argument of the defense, and when he was saying like things like, you know, you'll be a bad guy or whatever if you know, it's morally wrong to give somebody the death penalty and you'll be a bad guy or whatever. You're allowed to do that. And it shocked me. He's like, you can even do that to the judge. Like if it's a bench trial or whatever, or you're just, for any sentence, you know, when the judge is making the sentence, you can even do that to the judge if you want to play on the judge's morals. He says it's not a good idea, though, because then if you make the judge mad, then you might not get the sentence that you want. So you might not want to do that to the judge, but you're allowed to. And I was like, that's kind of risky. I wouldn't want to do that to a judge. I wouldn't go, look, judge, you're just a bad guy if you give this guy this sentence. Like, who wants to do that and anger a judge that's about to give a sentence? That's not smart. But you're allowed to do it, and I didn't know that. So I thought that was out of line. But no, he was perfectly okay by telling the jury that they would be bad guys, you know, that it was not moral to give someone the death penalty, that he was okay doing that. What he was not okay is when he reworded the jury instructions to make it seem like it would be illegal for them, like it would be premeditated murder. That was what was wrong, because you can't tell them that it's illegal when it's not.
All right, welcome back. It is now 3:14. We're a little early. Thank you for communicating your needs. While it's not customary that we interrupt councils, I can't have you there needing a bio break or medication or food. So if you have additional wants and needs, let us know. Don't hesitate. We are here to take care of you. Go ahead, please.
Thank you, Judge. All right, ladies and gentlemen, now I have to start over. All right, well, I was talking about baby Kennedy, okay? And I was talking about the needs of a 45-hour-old baby, right? What does a 45-hour-old baby need? Baby needs comfort, right? Baby needs to be held. The baby needs to be kept warm. The baby needs a mother. The baby needs a father. The baby needs a real father. But what did baby Kennedy get? What did she get? She got lured away from her family, from the family that had just given her all that unconditional love that a little baby needs, showering her with all the things that a baby needs. For 1 hour. She got lured away from that, and she got brought down to Levi and Sedgwick, where she was in the car when 5 shots rang out. That's what she got. She was in the car when her mother got shot 5 times in the head and neck. She was in the car when her mother got dragged out of the car and dumped on the side of the road like a piece of garbage. Then she got kidnapped. She got taken out of that car and put in the white Chevy with him. And she gets driven all the way back out to Lathbury, and she gets driven all the way back down to Mud Island. A trip with this kidnapper that lasted longer than the time she was able to spend with her grandma, longer than the time she was able to spend with her family. And then what does he do? He gets down to the river. She was in her car seat, but he takes her out of her car seat. Do we think during all that trip that the guy that wants to kill her is comforting her in any way? Do we think he gave her a bottle? Do we think he changed her diaper? Do we think he hugged her? Do we think he did anything to comfort that little baby? He gets out there, and what's the first thing he does? He takes her out of her seat. He takes her out of her seat. He takes her out of the last vestige of comfort that she had. It's February. It's 11:20 at night. It's cold. It's raining. It's raining, that cold steel rain that you get in February that we've all ducked and run from. And he walks down that old, decrepit boat ramp. There's rocks, there's mud, there's trash, there's old dead bushes and grass. And he walks down there and he gets her right to the water's edge. And this hat really should tell you, this is her hat. Look how tiny this thing is. And he walks out there and he gets to the water's edge. The Wolf River. The Wolf River, right where it goes into the Mississippi River. It's a dangerous river. It's cold. It's 38 to 42 degrees cold. It's so cold that your body will go immediately out of it super quick. There's dangerous currents. There's unpredictable currents. There are catfish and creatures in that river. It's dark. It's full of mud and silt and rocks. Premeditation. Because what does he do? Grabs her by her feet and throws her in. And her hat just falls right there by the edge. And as she's circling the water, going into that dark, cold void, what does he do? He just walks away. He just walks away. Let's think about intent and premeditation with respect to that act. Okay? What did he think? What do we think he intended when he took her out of her little car seat? What do we think he intended when he drove her all the way down to Mud Island? What do we think he intended when he drove her right to the boat dock? What do we think this guy intended? What do we think he intended when he took her away from her blanket on that frigid February night? What do we think he intended when he took her away from her mittens on that frigid February night? What did he intend? He intended to kill her. That, ladies and gentlemen, is premeditation, and that is also the most egregious kind of aggravated child neglect that one can imagine. Putting a little baby like that in that situation. It's cold, it's callous, it's premeditated murder. Now April Campbell deserves justice for what happened to her family. She lost her 27-year-old daughter. She lost her 27-year-old daughter. And we kind of lose sight of that because we talk a lot about baby Kennedy, but 27 years old. Murdered. 27 years old, 2 days after giving birth. Happy as she could be. She didn't need him. She didn't care about him. She would have been just fine without him. But he killed her when she was 27 years old. What else did April lose? What else did her family lose? She lost her little granddaughter. April Campbell got to spend an hour, 1 hour with her granddaughter. She deserves justice, ladies and gentlemen. Danielle Hoyle, Kennedy Hoyle, they were people. We talk about all these legal terms and we're having all our arguments and we have all the autopsy photos and all the jargon and all the mumbo jumbo, but don't lose sight of the fact. They were people and they mattered. You know, I've been so long. And when you have a case like this, it gets in your soul. It really does set with you. It leaves a mark on you, and it never goes away. It never does. And we've had this case for a long time, and when I get to this point, it's difficult. It's difficult to give it up. It really is. But now's the time. Now's the time for us to give the case to you. For us to give the case to you to make a decision, and we know that you'll do the right thing. We know that you'll do the right thing with the case. I'm going to ask you to bring back the verdict that common sense demands, the verdict that common sense dictates, the verdict that all the evidence dictates, the verdict that justice absolutely demands. Brandon Isabelle, he's guilty of the premeditated murder of Danielle Hoyle. He is guilty of the premeditated murder of Kennedy Hoyle. He's guilty of the aggravated child neglect of Kennedy Hoyle, and he's guilty of the murder and the perpetration of the aggravated child neglect of Kennedy Hoyle. And he's also guilty of the especially aggravated kidnapping of Danielle. I keep saying Danielle, of Kennedy Hoyle. And we really do appreciate your time, ladies and gentlemen. It's been a long, long road, and we appreciate your time.
When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with your decision to this courtroom, and your foreperson will deliver the appropriate verdict form to the court. The defendant has been charged with several crimes. The crime charged in each count of the indictment is a separate and distinct offense. The number of charges is no evidence of guilt, and this should not influence your decision in any way. It is your duty to consider the evidence that relates to each charge and to return a separate verdict for each count of the indictment. Your decision on one charge, whether it is guilty or not guilty, should not influence your decision on any of the other charges. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. If you find the defendant guilty on all counts from the evidence beyond a reasonable doubt, you should convict on all. If you find from the evidence beyond a reasonable doubt one or more counts guilty and have a reasonable doubt as to the guilt of the other counts or counts, you should convict on the counts you are satisfied by a reasonable doubt as to the guilt of and acquit on the others. If you have a reasonable doubt as to the guilt on all, you should acquit on all. In deciding the guilt or innocence of the defendant, you shall first consider the offense charged in count 1 of the indictment. If you unanimously find the defendant guilty of first-degree murder, premeditated killing, beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of first-degree murder, premeditated killing, or if you unanimously have a reasonable doubt of the defendant's guilt of that offense, your verdict must be not guilty of first-degree murder, premeditated killing. And you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within count 1 of the indictment. You shall not proceed to consider any lesser included offenses unless you have first made a unanimous determination that the defendant is not guilty of the immediately preceding. We have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in count 1 of the indictment, you shall return a verdict of not guilty and proceed to the next count. Verdict form. The charged offense in the indictment is first-degree murder, premeditated killing. The lesser included offenses within the indictment are as follows: second-degree murder, reckless homicide, criminally negligent homicide. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of first-degree murder, premeditated killing as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of first-degree murder, premeditated killing as charged in the indictment. If you unanimously find the defendant not guilty of first-degree murder, premeditated killing as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty to this offense, and then you shall proceed to determine whether the defendant is guilty or not of the lesser included offenses in order of their consideration as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of blank as included in the indictment. Insert in said blank space the lesser included offense. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment, under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we, the jury, find the defendant not guilty of count 1. You will write your verdict as to the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 1 of the indictment, you will next inquire as to your verdict in count 2. You will use the same rules in this count as you were instructed to use in the previous count. The charged offense in count 2 of the indictment is first-degree murder, premeditated killing. The lesser included offenses within the indictment are as follows: second-degree murder, reckless homicide, criminally negligent homicide. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of first-degree murder, premeditated killing as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of first-degree murder, premeditated killing as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of first-degree murder, premeditated killing as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty as to this offense. And then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offenses as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of blank as included in count 2 of the indictment. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof you unanimously have a reasonable doubt of the defendant's guilt of the of the offenses charged and included in the indictment. Under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we, the jury, find the defendant not guilty of count 2. You will write your verdict as to count 2 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 2 of the indictment, you will next inquire as to your verdict in count 3 of the indictment. You will use the same rules in this count as you were instructed to use in the previous count. The charged offense in count 3 of the indictment is first-degree murder, killing, and perpetration of aggravated child neglect. The lesser included offenses within this indictment are as follows: second-degree murder, reckless homicide, criminally negligent homicide. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of first-degree murder, killing, and perpetration of aggravated child neglect, as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of first-degree murder, killing, and perpetration of aggravated child neglect, as charged in count 3 of the indictment. If you unanimously find the defendant not guilty of first-degree murder, killing, and perpetration of aggravated child neglect, as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty as to this offense. And then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offense as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offenses in the indictment beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of blank as included in count 3 of the indictment. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof, you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we, the jury, find the defendant not guilty of count 3. You will write your verdict as count 3 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 3 of the indictment, you will next inquire as to your verdict in count 4 of the indictment. You will use the same rules in this count as you were instructed to use in the previous count. The charged offense in count 4 of the indictment is aggravated child neglect. The lesser included offense within the indictment is as follows: child neglect. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of aggravated child neglect, as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of aggravated child neglect, as charged in count 4 of the indictment. If you unanimously find the defendant not guilty of aggravated child neglect as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offense as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of child neglect as included in count 4 of the indictment. If upon all the proof, you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment, under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we, the jury, find the defendant not guilty of count 4. You will write your verdict as count 4 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. If, after you reach a verdict in count 4 of the indictment, you will next inquire as to your verdict in count 5 of the indictment. You will use the same rules in this count as you were instructed to use in the previous count. The charged offense in count 5 of the indictment is especially aggravated kidnapping. The lesser included offenses within the indictment are as follows: aggravated kidnapping, false imprisonment. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of especially aggravated kidnapping as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of especially aggravated kidnapping as charged in count 5 of the indictment. If you unanimously find the defendant not guilty of especially aggravated kidnapping as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty as to this offense. And then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offense as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of blank as included in count 5 of the indictment. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment under the law to find and explain to you, it is your duty to acquit him, and your verdict should be, we, the jury, find the defendant not guilty of count 5. You'll write your verdict as count 5 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and report to the court such verdict as truth dictates and justice demands. You may now begin your deliberations. However, 3 of you will not be joining your colleagues. We will be choosing alternates to remain seated as the jury goes back to the room to deliberate.
Number 12.
Hilliard. It is now 3:37. I suspect that Deputy Moore will have a conversation about the order of events. Those of you who are going to the deliberation jury room, she will speak with you on your way there. The 3 of you remaining, please remain seated, and we will follow the instructions of the Shelby County Sheriff's Office about our next steps. Thank you all.
Jurors excused when you know switching. Step 3 was remaining.
You may be seated. The court's going to be in recess.
Court stands in recess.
I don't think it's going to be that long. Now, in Tennessee, they do sentencing right after. So it's like, I remember with Carly Gregg. They did guilty, and then, if I remember correctly, because I didn't stream that one, I watched it on Recovery Addicts channel, and then I think they did, I want to say they did like a penalty phase. Kind of like they do when in Florida when they do the death penalty. There's kind of like a penalty phase where then they go back and they talk about whether or not they should get life without parole or parole. And then they came back. Like, not, it wasn't long at all. And all of that happened the same day. It was really, really quick on her. They found her guilty right away. Of course, there was video. Not video of her doing it, but video, like, because where the cameras were in her house, they had surveillance cameras in her house. And you could see her hiding the gun from the video cameras, and you could hear the shots. But where her mom was when she actually shot her...
No objection. Are you free to go about your daytime? State, you can call your next witness.
Your Honor, at this point, state rests.
What is happening now? Oh, no, we don't want to
The state has now rested its case, and as you can see, also up the deliberations clock for the baby in the river murder trial for Brandon Isabelle. The jury just got the case.
The defendant actually decided not to testify in his own defense. Earlier today, we brought you the closing arguments. Actually, we're going to bring you closing arguments of this trial coming up in our next couple of hours here at Court TV. You don't want to miss it. Stay tuned. We'll be right back.
Tonight on Closing Arguments, Vinnie Politan is back in studio as a man confesses to killing his parents on live TV. We talked to the news director about the confession.
Is that what you were talking about yesterday, Judy? Is that what you were talking about yesterday, Judy? Well, I guess we're not going to do that other trial if they've already rested. Good gravy, Marie. Okay, well, so much for that trial. Good Lord. They're just moving right along here. Figures we're doing a trial that's in Jill's neck of the woods, and she wasn't even here till closing arguments. I think... You know, I said about they're not allowed to play on the sympathies of the jury. I don't think I exactly stated that right. They're not allowed to put... They're not allowed to say, like... Put yourself in their shoes. So, like, that's why I used the example of that, of A Time to Kill. That movie. Because, like, by saying... Can you see her? Now imagine she's white. Because by saying that, that's like putting yourself in their shoes. And you can't do that. Like, you can't say, imagine if that was your baby. But the way he did... Y'all, I have never cried during a closing statement before. I have never done that before. I did not expect to do that. And Nichelle just said, I was about to cry when... he objected and stopped him on a... Yeah, and then when he came back, I did cry. And I wasn't even about to cry when he objected. I can't believe I cried. I've never cried. The only time I've ever cried, I cried during victim impact statements during the Brooks trial. That's the only time I've ever cried. And I don't think it's because I'm cold-hearted. I think it's because of being a nurse. I've trained myself to not react. Because that's something they teach you in nursing school. Like, you know, like if you're doing things, you're not supposed to react. You know, like if you're... Oh my God, Michelle, I am so sorry. Oh, that's awful. Oh, I'm so sorry. But like, when we do things like when we see wounds or something, we're not supposed to react because then you're going to freak out the patient. And so there's lots of times when I'm reacting inside but not outside, you know what I mean? So I rarely cry during a trial, but I cried this time. I didn't expect to cry. But yeah, he painted a picture. That rebuttal, that was the best rebuttal. Usually by rebuttal, I'm like, okay, come on, speed it up. Let's go. Let's get it to the jury. That was the best rebuttal ever. Ever. I starred a bunch. We might have covered it, but um yeah. She said what was, she wanted to know what last name they gave the baby. Um but I don't like she didn't I I think she was messing with his head, but I don't think she was being manipulative. But wait, you did say something, or I think it was you. Was she smart enough to know how he would react to her text? Was she trying to get him to think that way? Trying to think, well, maybe if I kill them, then she'll take me back. But you can't assume that that's what she was trying to do and then blame her for being manipulating. She could have been, but how would we know that? Because I mean, you could ask her, but she's never going to say that. So there's no proof that she was. So if she was, then she just got away with it. But what did it get her? It didn't get her anything because he's going to go to prison and then she has nothing. And I'm not really sure. I mean, it could have been like the defense attorney said it was reverse psychology that she was using on him, but we don't know that either. Maybe she really did want him to leave her alone. Or maybe she couldn't decide whether or not she wanted to leave him alone. So, and did she really wait until Danielle was in labor to say, well, you need to get to know her and, be a dad to her or whatever? Or did she say that before? We don't know. We only heard the text messages like right before she went into labor. So yeah, that's probably true, Jill. Yeah, I think so. Because we do watch some pretty horrific stuff. Like, not the actual horrifying part, but the aftermath. And so, yeah, like, I, pop- I popped into a Disney stream during the lunch break one time. And they're like, oh, so what trial are you doing? And I'm like, the dismembered wife trial. And they didn't even say anything. They just ignored it completely. like it was no big deal. um, yeah, I totally get that because I worked in a nursing home, and it was almost like not a, I mean, it wasn't happy, but it was almost like it's a relief almost. It's like, yeah, it's sad, and yeah, we miss them, but they're not, whatever their situation is, they're in a better place. So, but with a kid, and we don't know, because I don't think they ever mentioned, did Danielle know about Artesia? Was he stringing her along, or were they broken up? It didn't really say. They didn't really go into that much. So was this a triangle? They didn't really make that clear. I think if that had been made more clear, it would have shed more of a light on how much manipulating Artesia was doing. This kind of wraps up the whole case. He doesn't want to be with Danielle, doesn't want to be a new daddy, and he's just gaga over Artesia. And he's a dumbass. That sums up the whole case. So, I think he planned Danielle because he lured her out there. So I think the shooting of her was premeditated. And didn't he Google something about, can you tell what gun bullets came from or something? I don't think he thought out the baby, because I think that he drove around with the baby in the car, then he went home and changed clothes and left the baby in the car. Like, he had the baby and then was like, oh crap, now what do I do? But it was still premeditated because he had the baby all that time. He was just trying to figure out what he was going to do with the baby. So, it's premeditated, but it wasn't I don't know how to word it. Like, it wasn't pre-planned. Like, he didn't have a plan for the baby. But it was still premeditated in the fact that he knew he had to do something with the baby. So, kidnapping, yes. Because he's got this kid in his car, not knowing what to do with her. And I guess he just at the last minute was like, oh, well, I'll throw her in the river. But yeah, I think it was Nichelle that said he could have taken her to any of those, like, safe baby places, you know? And nobody would have asked any questions. He could have just, like, left her there anonymously. I used to have a friend that only read, like, murder mysteries, and her husband started getting worried. He's like, what are you doing? Are you trying to figure out how to get rid of me? And she's like, no, not no. Yeah, like, I mean, I can see getting involved with a man and not knowing he has a kid. But isn't that kind of a thing you should know when you start seeing somebody, if they already have baggage? I mean, like, I asked if Travis had kids before I even met him because my friend fixed me up with him. So that was one of my first questions. Does he have kids? And yeah. So I knew before I even laid eyes on him that he had kids. I was also 37. So, I mean, I wasn't a stupid kid either. Yeah, that's the thing that gets me. It just like garbage, you know? And And the way he says he was carrying her like this, or I don't know if he was carrying her like that. Well, you can't see my arms because the comment's there. But like carrying her like a baby. And the hat wouldn't have fallen off because it was against his arm. But that's not how he was carrying her. That's why the hat fell off. And it wouldn't have mattered if they got the DNA at the hospital because they still would have had to send it out to be tested. So I wish I could remember how Tennessee does the penalty phase or whatever, because I don't know. So it's 5 o'clock here, it's 4 o'clock there. I don't know how long they're gonna take, and I don't know how long the penalty phase is gonna take. And this judge's time management, Jill, the state rested yesterday. And, well, first off, we were here Saturday. She made him come in. And Friday, she told the lawyers. Dang, I forgot what she said. Something about how hard they worked would depend on if they were going to be there Sunday too or something. I knew the quote and now I forgot it. But I think she was punishing the lawyers. How hard you work depends on if you're going to be here Sunday too. Something like that. And then at the end of Saturday, she tells the jurors, we're ahead of schedule. Why are we there on a Saturday then? So then, yesterday, at almost perfect timing, the state rests. It would have been a perfect time to end the day. It was what, guys? Like 4:30 their time, I think? It would have been perfect time to end the day. She says, defense, how long is your witness going to be? How long is your direct? About 45 minutes. How long is your cross going to be, state? About a half an hour. Okay, let's do it. I was like, oh, good Lord. She tells the jury, we're going to be here as long as we need to be here today. So my time, it was after 7 before we got done. Go to start today. What time did we start, y'all? We sat here, and we sat here, and we sat here. And then they started the charging conference, and they didn't show us any of it. And then they said, oh, we need 20 minutes to look over the jury instruction. So we waited 20 minutes. And then they came back and they talked a little bit and they said, we need another 20 minutes to look over jury instructions. And then, 30, 40 minutes later, it seems like so much of the time is just... And then when they asked him if he was going to testify, they actually put him in the witness chair. And I thought he was about to testify, and I got all excited. And no, his attorney just asked him if he was going to witness, if he was going to testify, and he said no. I'm like, why did you have to put him in the chair for that? I thought he was actually going to testify. This has been the most bizarre trial ever. So I don't know what's going to happen. I don't know if we're going to get a judgment tonight. I don't know if we're going to, if we do, if we're going to get the penalty phase tonight. I don't know what's going to happen. So we're not going to anything else. We're not doing anything else. We're just gonna sit here for a while before I call it quits. Because sure as the world, if I shut everything off, they're gonna come back with a verdict. Or someone's gonna text me and say, Debbie, there's a verdict. Oh. Yeah, he knew. I don't understand. If he was writing her before, we're going to raise the kids together as a family, we're going to make this work, whatever, that I could understand. I could understand him trying to talk her into it. I love you. I don't love Danielle. I don't want to be with Danielle. But I've made this baby. I'm sorry, but we can make this work anyway because I love you that much. You know, something along those lines. And then he did it. And then pretended he didn't do it or whatever. I could get that. But why did he do it and then write the stupid card saying they were going to raise them? Even say he was going to try to get full custody of the baby, knowing that she didn't want him to have another kid. Why would he then tell her he was going to try to get full custody of the baby? That doesn't make any sense. And he would think that that would change her mind? You're absolutely right, Michelle. 100%. 100%. Why am I trying to do that? I don't know. Like the same with going to the hospital. But I think what you said about going to the hospital is right. I think Danielle probably thought if he could get her to go and see the baby, that he would see her and fall in love with the baby and decide that he wanted to try to be a good dad or whatever. But I don't know. And with Jose Soto Escalera, see, I've never done a trial with like a child abuse thing. I've watched them before. I've never covered one because I've never wanted to delve into these kind of question and answer sessions and like really talk about it, because I was a peds nurse. I was a preschool teacher. I love kids. I couldn't have my own. I've got nieces, nephews. I've got a goddaughter. I've got stepdaughters. I don't have any of my own. I've never wanted to like delve into this. And so I did Jose Soto Escalera's trial because it was a death penalty trial, which I'd always wanted to do. I don't know why. Just curiosity, I guess, because I'd never done one before. And I thought because the baby hadn't been born yet that it wouldn't be as bad. And I guess in a way it wasn't. And so I thought, well, this baby is just a couple days old, so maybe it won't be as bad, but it was so much worse. It was so much worse than the other one. Hearing the grandmother talk about only get to seeing the baby for an hour and like dressing it and bathing it and stuff like that, and then imagining the way he got rid of the baby, it's just so much worse. So I really apologize, y'all, because I did not think about how much worse it was going to be. I really thought it was going to be about the same, and it was so worse. So I apologize. I don't think Artesia wanted him to do that. I think Artesia wanted him to find out, like, concrete proof that the baby wasn't his. Therefore, if it wasn't, then she was going to say, okay, we can be together, and then I won't have to worry about her claiming that it's yours and trying to mess with us. I think that's what Artesia wanted. and that if it was his baby, she didn't want anything to do with him. She wanted him to be the father he needed to be for that baby. That's what I think her mindset was. I could be totally wrong, but that's what I think. That's what I get from those text messages. And you know how you were talking about the non-trusting relationships. I have a boyfriend in my past that I could not trust. None whatsoever. And you know the saying, if they will cheat on you, if they'll cheat with you, they'll cheat on you. And I think he did both. Because, like, one time, we were on again, off again for years. And at one point, he had been married, and then we got back together. He told me he was separated from his wife, and I don't think that was true. In hindsight, I don't think that was true. I think he lied to me. I think he was still married. At the time, I didn't. At the time, I thought he was separated. But looking back at some of the things, it seems suspicious now. At the time, it didn't, because I thought I was in love with him. And I guess maybe I was in love with him. Ooh, I'm so glad. Anyway, and my husband's ex-wife cheated on him. So we both been in. So we have total trust with one another. There's no way would cheat on each other. So there's total trust. And I was teasing him the other day because he had, I don't know, he'd gone to the store after work and didn't let me know, and like he was gone, like he didn't get home when he should have gotten home, so I was teasing him. And so we had gone to bed that night. I didn't say anything when he didn't come home when I thought he was going to. And I waited till we went to bed, and I was like, "Are you cheating on me?" And he goes, what are you talking about? Like, I threw it. It's like he didn't. It came out of left field because, like, he had no idea where it came from, and he was, like, shocked that I would even say that. And I'm like, I'm just teasing. And he goes, "What are you talking about? Of course I'm not cheating on you." I said, "I'm just teasing. You didn't come straight home from work." He's like, "Yeah, because I went to," I'm like, "I know. I saw you come in with a bag of groceries. I know you went shopping. I'm just teasing you." Aw, Jill, that's so sweet. Yeah, pretty much, Travis is the same way. No, I had another boyfriend that treated me okay. We just didn't. We made better friends then. We're still friends. The one that I showed you his baby's picture the other day. We make better friends than we do a couple. And we figured that out. He was good to me. We're friends, not romantic. We don't work romantically, but we're friends. So there's this guy. I haven't met him. But it's a guy that I know online. Very nice guy. And I keep teasing my husband. I need to quit teasing though, because he's one of the Disney streamers that I watch, and I gotta quit teasing Travis because I'm afraid Travis is gonna start taking it seriously and not gonna let me go to Disney by myself for fear of this guy. the other day, his picture popped up in like a montage of Disney pictures on one of my friend's channels, and I'm like, and I paused it, and I'm like, there he is, honey. There's your competition. I'm like, I'm just kidding. You don't have anything to worry about. I'm just teasing. Yeah. Yeah, that's like that one ex. Like, we're friends now. We did plays together. We went to high school together, and then we did plays together in the, like, our local community theater. And he ended up, he moved to Tampa, and he started performing at Busch Gardens, and he ended up being, like, in charge of entertainment at Busch Gardens for the longest time. And then he ended up touring with some, I can't remember what the name of the group was. It was a musical group, and they did covers of like oldies, like doo-wop, like old 50s doo-wop songs. And gosh, I'm not even sure where he lives now. I mean, he's back in Florida, living somewhere in Florida now, and he had a baby when he was 50. That is the cutest kid. And I don't know if he got married or if they're just a couple, but she's younger than he is. But that kid is so cute. That's a darndest cute little kid. But yeah. Yeah, you definitely would get along better. We don't fight. We fuss at each other, but we don't fight. And remarkably, I didn't do this on purpose, but I have a personality like my mom's, which I don't really like, but I can't help it. And Travis has more of a personality like my dad's, and we fuss like my parents did. Like, my parents didn't fight. It was never like real screaming, yelling, fighting, slamming doors. It wasn't like real fights. It was just like, when are you going to clean up this mess? When I get ready. I thought I told you to do that. Well, I'll do it in a minute. Leave me alone. Like that kind of like fussing. We call that fussing, not fighting. That's just what we do. And, it's not a real fight. It's just like, and then when it gets to the point that we're tired of fussing at one another about something, then we'll go do what we wanted the person to do, or we'll be like, well, he's not going to do it, so I'm going to do it, and that's just, it's not ever anything serious. We never, and that's how my parents were. I'm trying to think if I ever saw my parents really, really fight. Ever. I hear stories about couples where they're like, well, I picked up and got the kids, and we picked up and went to my mom's house or whatever. Never. My parents never did that. I've never done that. Like, I've never been so mad that I wanted to leave the house and get away from him. And my parents were never like that either. Like, I don't. And Travis is my best friend. I tell him everything. Even sometimes something will happen and I'll be like, I can't tell Travis about that. And then, like, 2 days later, I'll be telling him about it. I tell him everything. He's my best friend. Oh, that's not. That's not good. That's not good. No, I used to, things that I thought was funny about Travis, like, I would try to make, now my mom did this to my dad, and my dad, like, my dad never said anything. It didn't bother my dad. It bothers Travis when I do this. So I've learned to stop doing it, and I still sometimes will do it, and I'll catch myself. Something he does that I think I'll act like it bothers me, but it doesn't really, and I'll like make a joke out of it. And then it embarrasses him. And so one day we were at his sister's house, and like his whole family was there, and I was making some joke about something he does that bugs me a little bit. I don't even remember what it was now. Something about, oh, I remember what it was. It was leaving the AC off in the truck to get better gas mileage or something, which I hate because I don't like the heat and I get hot really easily, and I like the AC on in the truck, and so I was making like a joke out of it, and he got really upset about that, and so I apologized and I said, I'm sorry, honey, I won't do it anymore. I'm very, very sorry. And so I don't do it anymore. But to me, it was just funny. I was just making like a fun joke out of it, And so you have to remember those kind of things. Like if you don't want to hurt each other's feelings, like I just thought it was funny. To me it was nothing, but it hurt his feelings. So you have to remember those things. You can't just go through life willy nilly thinking, it's not about you. It's you have to work at it. It's not. If they don't like it, then you have to adjust, it's not. Yeah. See, like, and I guess it's because I watch true crime and I see, like, toxic couples all the time. I mean, look at Betty Broderick. She's as toxic as they get, right? And so I see all these toxic couples, and I will do something so stupid, and Travis will just stand there and laugh at me, and I will go over to him and just give him a big hug, and sometimes I will literally say, thank you for laughing and not knocking me across the room or something, like he never would, but some of the things I do, I can just think about some of the trials I've watched or documentaries I've watched. The littlest thing some of these men will beat their wife for, And like, okay, so you guys know I diamond paint, right? So one time I had gotten done with a project and I had a bunch of leftover those little diamond dot things, and I had thrown them away. And then I went to dump the whole garbage can out. And I don't remember what happened. I don't remember if I dropped the garbage can or there was a hole in the bag or whatever. But disaster struck. And there was these little diamond dots all over the dining room floor. And I just was standing there with a garbage can and a bag and all these little dots all around my feet. And Travis just stood there and busted out laughing. Didn't yell, didn't say a word. Just stood there laughing at me. And all I was just look at him and smile. And the love I felt in that moment. Because it was like, I'm gonna cry just thinking about it. I could have married somebody else that might have wanted to backhand me for doing that, And that's just the way he is about. And I lose my phone 5 times a day, I swear. And every single time I say, I lost my phone again, he laughs. Every single time. Every single time. I lost my phone again. Will you please call my phone? He laughs every single time. So I just feel blessed that is the man that I married. That I didn't marry someone that's like, oh my God, Debbie, you drive me crazy. You do this all the time. What is wrong with you? So I'm just blessed. I'm just so blessed. Well, there you go. You hit him back. But, and I don't know why, like, my parents weren't abusive to each other. They had a great marriage, too. So, I don't know why I just, like I said, it's got to be the true crime. It has to be the true crime. But I just, when I do something stupid, that's what pops in my head, is that I could have married somebody that could be beating me for doing this right now. And I don't, like I said, I've never been hit. I don't, well, I was in the guy that I was on again, off again with, he was verbally abusive. Verbally and emotionally abusive. So, um, that, had we ever, I think, that would have eventually, I think that would have been physical had we married, but I'm glad I never did. Man, the mind games that man played on me, and maybe that's why that's where my head goes, because I think that might have turned into that. Oh. Travis! My mom always said that she wasn't in, that she'd never been in love. My mom had been married twice. Her first husband was, my dad told me this after my mom died. I didn't know this when she was alive. She divorced her first husband after he hit her for the first time. My brother was 16 when they got. He was 16 when she married my dad. So, and I don't know how long she'd been divorced, but my brother was a teenager when she got divorced. So they were married for a long time, but he would accuse her of cheating if he came home and like the pastor from church had come around to visit. He would accuse her of sleeping with the pastor. So like, it was horrible. Like, she said she got to the point that she would break out in hives when he came home from work. Like, she got a literal reaction from his presence, because she got so anxious and scared around him. So I knew that, but I didn't know that he had eventually did hit her, and that's when she got divorced. He might be in the shower. His other job, when we met, he was, on our first date, I'm like, so what do you do for a living? I'm a rubber liner. Like, what the heck? He used to get in these big, he was an industrial worker. If he'd said that, I wouldn't have known what it was either, so. He used to get in like these big tanks that held fertilizer, and they took chipper hammers, which are like miniature jackhammers, and they would like the hardened fertilizer and stuff, they would take them and chip out the ones that was stuck to the wall, and they would clean them all out, and then take rubber, like it was kind of like, I never watched him do this, he explained this to me. So they're in this giant like hazmat suit kind of a thing inside this giant tank that's like as big as this room, which still I would have been claustrophobic. It would have killed me. and then they sprayed with like a power washer thing. I don't know technically what it was called. Rubber, like liquid rubber. And then it would line the walls of this tank so the fertilizer wouldn't eat through the metal on the tank. And that's what he did for a living when we met. And then he moved up here, and there's not that kind of work up here because it's out in the country. And he did all kinds of different stuff all over, and it was like seasonal work and temporary work and stuff that the farm work and dairy work and that kind of stuff. We have a lot of people with green cards around here. I don't know if they're called green cards, work visas, whatever, that come and do that kind of work and then send money back home to Mexico or wherever. It's like all around where I live, it's all Mexican people. And now one of my neighbor that I don't like, that closed our road, and it's caused a huge headache for me, where FedEx is concerned, especially. Used to be our friend. He's the one that got Travis's job at the feed store in town, and he's worked there now for over 5 years, 6 years. And so he works there Monday through Friday, 9 to 5, and that has been just a blessing because they have been so good to us. When I need anything, I need Travis to do anything for me, come home. I had him come home one time to kill a snake. I called him, I'm like, you have to come home now. There's a snake in the yard. I don't know what kind of snake it is, and I'm not going out with the dogs until you come home and kill the snake. So he's like, I gotta go home. There's a snake in the yard. They let him come home. He came home, he killed the snake, and then he went back to work. Yeah, you need a man that has your back. When we first started dating, his ex-wife is a bitch. So she has 2 kids from her second husband, and then his 2 girls. So when we first started dating, we started dating in November. So Valentine's Day rolls around. I get cards and little Valentine's Day candy. Casey's birthday's the day after Valentine's Day. Day after? 2 days after. Day after. So I call her up and I say, I have Valentine's Day stuff for the girls, and then Travis had put some money in the Valentine's card for Casey for her birthday. So I say, I have Valentine's Day stuff for the girls. Can I come over? And she says, yeah. She said, did you get Valentine's stuff for the other 2 kids? And I said, no. And she said, well, if you're going to the other 2, because they're Uncle Travis. He's Uncle Travis to them. So if you're going to date him, you're going to be Aunt Debbie. So you're going to have to get stuff for the other kids too. So he has a brother, but he's married. And he has a cousin, but he's married too. Oh, you don't want Travis's dad. Trust me. Travis's dad's a murderer. Travis's dad killed his mom. Travis's dad's dead now. That's another story. So I called Travis, because Travis lived like 2 hours away at the time. So I called Travis. I'm like, you're not going to believe this. So I told Travis what happened. I get to the house, and then she comes out to the car. And this is her apology to me. Dipshit told me it was his fault you didn't have anything for the other kids. That's her apology to me. Oh, I'm so pissed. So pissed. Ugh. Well, that's Travis's ex-wife. Yeah. Okay. This is good. This is good. You know, we were talking about Artesian. Is she at fault? He's home, though. I don't know if I want to tell this story now. Okay. Travis's dad, they lived in Polk County, and he went to work in South Florida. Polk County's like Central Florida. He was a house painter. He went to work in South Florida and met Travis's stepmom while he was still married to Travis's mom. Told her he was going to go back home and ask for a divorce. Then Travis's mom went missing. She was kidnapped from a parking lot. Never been found. So he goes back, continues to date this other woman, eventually marries this other woman. Do you think that she truly believed that Travis's mom was kidnapped? She says she did. Until he was abusive and she divorced him. Now she believes that he did kill her. But do you think she believed it at the time? Never been found. And he didn't say, when the police questioned him, he didn't say, I didn't do it. He said, you can't prove I did it. And he told his daughter, Travis has a half-sister that he had with his second wife. And he told his daughter there's lots of places in Florida to hide a body. So we got married in October. His dad died of cancer in October. So, newlyweds, I'm at the hospital with him. Detectives show up. My little true crime heart going pitter-patter, man. I was like, wow. His now third wife from Costa Rica, I don't know if it was like a mail order bride or what she was, wouldn't let the detectives even come in the room to talk to him. Wouldn't let his kids in to see him. The charge nurse, bless her heart, arranged for the kids to go in and see him, his adult children, Travis and them, to see him when the wife wasn't there. Crazy. Hey. They want to see you. They're jealous because I have such an amazing husband. They said, does he have a brother and is he married? I said, yes and yes. Is that a close cousin and is he married? I said, yes and yes. They said, Dad? I said, oh, you don't want his dad. Because I'm scared to death of snakes. And I didn't know if it was poisonous or not. I thought it was a baby rattlesnake. Because I had heard that baby rattlesnakes didn't have rattles yet. And I hate snakes, so I didn't know for sure. And I had the dogs out there, and I didn't want anything to happen to my dogs. So that's why. Travis said he felt very, very bad for killing the snake. But he did it for me. Because I told him, I said, I'm not taking the dogs outside until you come kill. The babies won't bite? Are you serious? I heard that baby rattlesnakes were more dangerous because their venom was concentrated. Like they had the same amount of venom that adult rattlesnakes do, and that they're more dangerous because it's like concentrated because they're little and they have the same amount of venom. They don't bite. Are you serious? Okay. Well, get over here where they can see you. You're gonna have to get down.
I know, I was doing that.
This is my honey. Say hi.
Hi. Hi, everybody.
They're jealous. You're not dumb. Wiggles waved at you, Travis. Wiggles waved at you. Wiggles. Leah. She waved at you. She said, I'm dumb. I said, no, you're not dumb. She goes, wow, I just waved at him. Jill says hi. Okay, what did I miss? Who tried to appeal, Jill? What did I miss? I used to hate spiders, and then I saw a video of a jumping spider on Facebook or YouTube. I don't remember which. Anyways, so then I started liking jumping spiders, and I found a jumping spider, and I brought her inside, and I got a mason jar, and I put holes in the top of the mason jar, and after doing a little bit of research online, I put some dirt in there and leaves and twigs and stuff, and I put her in there, and I caught some grasshoppers and stuff and put in there. I couldn't get her to eat. She would come out and crawl on me and stuff, and she'd wave. She was so cute, but she wasn't acting right, so I put her back outside. So Michelle said hi too, honey. He says hi back to everybody. So then I let her go because I was like, I'm not going to kill a spider that is nice and isn't going to hurt me. And like, she liked me. She'd crawl all the way up my arm and she'd wave at me, and she was so sweet. But I guess I didn't have the right kind of food or something. Like, I didn't know why she wasn't doing that well. So then I was like, Travis, I want a spider. We're going to have to go to a pet store. It was doing that to Judy. Was it yesterday? Yeah, yesterday. So we go to this pet store, which is a reptile store. I'm like, okay, so I'm at the door. He's in the store. I'm at the door. He's like, get in here. I'm like, no. Do you want a spider? Yeah. Go buy me a spider. Get in here. There's a snake over in the corner. This big around. I swear, no. It's in a cage. It's not gonna hurt you. Get in here. And I'm walking through the store like this. Because I don't want to even accidentally touch a cage with a snake in it. Would you stop? I don't want to be in here. Get over here. We're buying you a spider. So I get this itty bitty, itty bitty, teeny tiny jumping spider, right? And we buy a habitat for it. So I put him in there with the sand and the twigs and the leaves, and I bought like live baby crickets or something to feed it. So I feed it. I'm watching it, everything. And then one day I look in there, I can't find him. He's like nowhere. And in the meantime, I have got onto a Facebook group that teaches you how to do jumping spiders. And I realized my jumping spider's no longer in my habitat. So I'm talking to my spider group and I'm like, how did my spider get out of the habitat? I don't understand. I swear I bought a spider. He was there yesterday, and they're like, what brand is your habitat? And they named the brand. I forgot now what it is. Did you have a such and such, whatever it was? And I was like, yeah. And they're like, that's why they can get out of those. And I was like, oh, wonderful. $30 we paid for this stupid spider. Now, they're everywhere in my backyard, and I wasted 30 bucks on a stupid spider. So I have had so many jumping spiders. They're everywhere in Florida. So now I just go outside and look for a spider, and then I'll bring it in, and I'll put it in there. I'll I'll just like watch it for a few days, and then like if it starts to not really act right or sluggish or whatever, like it's not doing too well, then I'll take it outside again. But what I do is I get I forgot what kind of worms they are. They sell them at PetSmart and Petco, and you stick them in the fridge, and they go into hibernation. And then you bring them out, and okay, Jill. I don't know what's going on with YouTube. It keeps doing that. It kept doing that to Judy yesterday too. So then you bring them out of the fridge and you let them warm up, and then they start wiggling around again and waking up, and then you just stick one in the habitat with the spider, and then you stick them back in the fridge. So actually the last batch I had, they all died, but they stay alive for a really long time in the fridge. So I need to go get some more, so the next spider I catch, I'll have food for it. But I don't have one right now, but usually I have a couple. But just jumping spiders. The other spiders I don't. Now the banana spiders, I think is what they're called. For some reason, they love my front porch. And in the summer, I usually have 2 or 3 with great big giant webs on my front porch. And so I have a couple right now out there. They're great, big, beautiful. Now they have venom, but they're not, like, it won't kill you, but it will hurt if they bite. So I don't mess with them. I just leave them out there, and I don't kill them. I don't do anything to them. I just let them be, and I think they're beautiful. I'll just go out there and just watch them sometimes. I used to be really afraid, but the jumping spiders made me not afraid of spiders anymore. Now, if I don't know what they are and I think they might be like dangerous spiders, I'll kill them. The other day I went, there was one in the bathroom. It was big and brown and ugly, and I didn't know what it was. And I was like, Travis, come get this spider. Because I didn't know what it was. So I wasn't taking any chances. Yeah, see, we do have those too. And there are brown spiders that we have in Florida. And if you use the Google, what is it? The Google image thing, I don't remember what it's called. It will say that it's either a brown recluse or a brown house spider. That doesn't help me because it doesn't tell you which is which. It could be either. So if I don't know, it's getting killed. I'm sorry. I'm sorry if you're a nice, just brown house spider, but I'm not gonna take that chance. So, yeah, you're dying because I don't want to accidentally. I had a friend. Well, I still have a friend. I just haven't talked to her in a while. That when she was a kid, she got bit, and so her whole entire arm is scarred up. She looks like she's been burnt because she lost so much of her arm they had to do skin grafts. She was in the burn unit, like if she had been burnt. Her whole arm is like, it looks like she's been in a fire. It's awful. Oh my god. Oh my god. Yeah, I wouldn't have to pee anymore either. Absolutely. Absolutely not. I would no longer have to pee. Absolutely not. No way. No way. Yeah, that would scare the pee right back up inside of me. I think I know why I'm afraid of snakes, though. When I was a little girl, my dad could tease you with a total straight face, and you would have no idea he was kidding. And even at the age of 5, I knew that about him. So I had gotten to the point that he would tease me, and I would say, "Shut up, Dad. That's not true. No, it's not." Even at 5. So one day, and my dad, if he was not in his uniform, I went wherever he went. I was a daddy's girl. So he had, of course, like I've told you many times, this is his farm. He grew up, and this was all farmland, and he grew up on a farm. So, he had a little garden outside when we lived in Bradenton when I was a little girl, and when he was on his days off, he would work out in his little garden, and I would play out there and stay and drink out of the garden hose like Gen Xers did and all that, play in the dirt, in the mud, and I was daddy's girl out there with him. We'd eat green beans all the time, and, day, he's like, "Debbie, standing on a lake." I'm like, "No, I'm not, Dad." "Yeah, you are. You're standing on. No, I'm not." "Yes, you are, Debbie. Look down." And I looked down, and I was standing on a snake. I don't know what kind of snake it was, but I jumped off of it immediately, and Dad had a hoe in his hand because he'd been working the garden, and he chopped the snake up, and it kept moving. And in my little 5-year-old mind, I thought, you can't kill a snake. And Dad, with the old wives' tales, of course, the snake keeps moving because of its nerves, and, until the nerves stop firing, the snake still moves. But Dad's old wives' tale was a snake will still move until sundown. It doesn't matter, but in my little kitty brain, I was like, "Oh, you can't kill a snake. No matter, you can cut it up into pieces and it's still alive." So, I've been terrified of snakes ever since. So, I think oh, my phone. Okay, my stepdad will be in prison the rest of his life for holding a man against his will. My phone is not cooperating. Beating the hell out of him and setting him on fire. Oh my God. Miraculously, he survived once my stepdad passed out after a week-long binge on crack. The neighbor found him crawling in the front yard trying to escape. Is that why you had to testify? I always forget to ask you. You told me that one time you had to testify in a trial and you were nervous, and I always forget to ask you what the trial was about. Is that what it was about? Good Lord. Why did he do that? That is horrible. Okay, now I gotta go find the one about the parole. He tried to appeal that he put the fire out. All appeals have been denied. Thank God. Oh, he burned him, but then he put the fire out. Yeah, well, nice of him. Jeez. Well, oh. That was the guy that admitted to killing his parents. And I went to turn the sound on, and then it was over. Well, guys, it's almost 6. I guess. Oh. Why did he threaten to do that? Boy, Jill, you've been through it, haven't you? Wow. So, let me see. What happened with that? So, this is what law and crime is showing. Does that mean they're back in the courtroom, or is that just what law and crime is showing? I'm trying to find out if that other trial,
You go outside, son?
because they said that the state rested in that other trial. But is it over? Or there's going to be a defense? I can't even find it. Oh, there it is. Oh no, there's more trial tomorrow. Well, I guess I don't know what to do. What time is it there? 5? How long have they been out? They don't even have a clock going on court TV. Well, the chat on Law and Crime is being impatient. This isn't a hard decision. Come on, people. I can't believe the jury. They're trying to give Brandon hope by taking so long. The baby is his baby. They took less time for the Adelsons. Oh, and some idiot, in all caps, Karen Reed got away with murder. What idiots. Oh, thank you, Judy. An hour and 20 minutes. Oh, now Court TV puts up the clock. Okay. I will let y'all go, and I will keep watch, and just make sure your notifications are on. If they come back tonight, I will be back. But I'm gonna go eat dinner, and I promise I will keep an eye on it. So, this has been nice. We've spent a lot of quality time together today. So, remember, be kind to people, love your family, and Jesus loves you. And so do I.